Okay, we're here today to continue the hearing from late June, I think. I've lost track of the dates, June 30th, to hear and decide an appeal application submitted by Craig D. Justice on behalf of John and Samantha Solic, Marvin and Rebecca Bennett, and James and Angela Post regarding the December 30th, 2022 Administrative Development approval related to certain development at 908 Williamson Drive. I'm Rodney Swink, Chair of the Board, and our board members are all here and present. So I believe we left it with the city presenting their case, and I think you're still up to present witnesses. Ms. Tatum?
Yes, just quickly a few things. I have Andrew Seymour sitting with me today from the City Attorney's Office because Ms. Hill has had a baby 10 days ago, so good for her. Baby James. So that's the first thing. The second thing is I wanted to hand up a couple of things. We have reason to believe that our system is going to crash at some point because of the heat. So we have printed out the PowerPoint in case that happens so that the board's able to follow along. So if I can just go ahead and hand those up.
Go ahead.
These are exhibits, copies from the record, copies from Supplement 19. So all of this is...
And while you're doing that, I want to also add a note I meant to add in the beginning. Given the nature of the room we're in and how hot it is, I really would ask all of you involved in this case to please move expeditiously. We'd love to get this wrapped up. I know you're going to do everything you need to do to make your case, but please be respectful of the fact that we'd love to move this thing along. So, thank you.
Okay, and the other thing, we also have a supplemental brief that addresses some of the statutory interpretation questions regarding plural versus singular, and then we have the last exhibits that we're going to offer. They're not in your notebook, so I thought if I could get those all to you, that would save some time. Okay.
Go ahead.
All right. I'll take to Craig. Yep. I'll take this over, and you do. Yep. This thing. I don't think I need this. I'm gonna try, but let me.
Blue shirt up against the wall there. He's representing the development that's. You got that one. Michael Birch.
Yeah, unless you, yeah. I do a little on the go.
Yeah.
State statutes too.
While we're doing that, our first witness is going to be Justin Romea. So, did I give enough? Do you have enough copies, guys?
Okay, Mr. Romea, we administered the oath before, so I think that still counts for you today.
Okay.
Justin Romea. But for the court reporter, just state your name again, please.
Justin Romea, Rametta.
We ready? Okay. Can everybody hear me? Okay. All right. Again, you've just stated your name, but will you state it one more time for the record?
Justin Romea.
Okay. And how are you employed, Mr. Romea?
I am the zoning administrator for the city's Planning and Development Department.
Okay. And how long have you held that position?
Since March of 2020.
And what was your position before that?
I've had several positions with the city's planning department or its predecessors since 2013.
And what was your job before that?
Previously worked as a planner at Wake County for approximately 7 years.
Okay. Are you familiar with the Raleigh UDO?
Yes, I am.
Okay. And how are you familiar?
It's my job to be familiar with it, and I work with it on a daily basis.
Okay. What are the primary job responsibilities of you as the zoning administrator?
I supervise a team of zoning inspectors and zoning code enforcement officers. I also supervise a team of planners that's responsible for staffing this board. They also draft text amendments to the city's Unified Development Ordinance. I also participate in that drafting, and it's my responsibility to provide interpretations of the UDO as well.
Okay, and how many zoning administrators are there in the city?
There's one, myself.
And that's you?
Correct.
Okay, and with respect to interpretations of the UDO, are you the final say, if you will?
Yes, that is my responsibility.
Okay, can anyone other than the Board of Adjustment, of course, any other staff, are they able to overrule your decision in any way?
No.
Okay. Can you tell the board just generally what the missing middle text changes are, or were, or continue to be?
There were a series of text changes that the City Council has adopted over the past several years. They're primarily aimed at promoting housing options and choices and housing affordability. They did that primarily by increasing allowable density and unit yields throughout the city, or most of the city, and allowing additional building types in certain districts where they were not previously permitted.
Okay, and you've heard reference to missing middle 1 and missing middle 2. Were those the two primary text changes that are referred to as missing middle?
Yes, that's right.
Okay, and which one is relevant to this appeal?
The missing middle 1 ordinance, TC-5-20.
Okay, and can you tell the board what those letters and numbers mean, TC 520?
TC stands for text change. The 5 refers to that being the 5th text change that the City Council authorized in the year of 2020.
Okay. And are you also familiar with the property at issue in this appeal?
Yes, I am.
And can you put up slide 2, please? We're going to let Justin run the slide to be less disruptive. And this has been admitted previously as Exhibit 3. Is that correct?
Yes, that's correct.
And you're familiar with the area?
Yes, I am.
And can you identify the property owners subject to the appeal?
Yes, it's the...
That have filed the appeal, excuse me.
That filed the appeal, yes. It's the property owners highlighted in green, the Solics, Posts, and Bennett's.
Okay. And how is the 908 Williamson property zoned?
Residential 4.
Okay. And have you reviewed the appeal that was filed by the appellants in this case?
Yes, I have.
Okay. And in your opinion, do any of those grounds for appeal have any merit?
Objection. Mr. Chairman, this is going to be a running objection potentially today, and so hopefully I can just do it once, that this witness is being asked to answer a question that usurps your authority as it relates to questions of law, which is how you read ordinances. So obviously you can consider his opinion, but there's this fine line between this is his opinion and him being able to testify as to a legal question. So,
Okay, Mr. Justice, thank you. Noted.
Okay, and we're offering him up as the zoning administrator for his opinion, and 100% agree that the ultimate determination as to the meaning of the code is with this board. Okay, I'm going to hand you what's been marked as the city's Exhibit 5. This is what's in your notebook. This has been in your notebook from the first day, and ask if you can identify that.
I can. This is an affidavit from me.
Okay, and is the information in the affidavit correct?
Yes, it is.
And does it set forth basically your opinion about whether or not this approval was correctly issued?
Yes, it does.
Okay, I would like to move to admit that as Exhibit 5.
just subject to my general objection.
Yeah, yes, sir. Thank you. Okay.
I'm going to hand that to Ralph. Okay, just some questions about the approval in the UDO. What is the type of approval that is the subject of this appeal?
It is a preliminary subdivision approval plan.
Okay. Is it an administrative approval?
Yes, it was.
Can you explain to the board what an administrative decision is?
It's a decision where staff is the final decision maker on whether to issue the approval as opposed to the city council or planning commission, et cetera. Staff applies the objective standards that are in the Unified Development Ordinance. If the plan complies with those standards, they're obligated to approve it.
Okay, and this is how the UDO was set up as approved by the city council.
That's correct.
Okay. Can you just also explain, just quickly, how the subdivision process works from the time it gets submitted until it gets approved?
So an applicant files an application along with the plans and any relevant documents. Those plans and documents are disseminated to a review team of staff. It's a multi-departmental review. In addition to planning and development, the transportation department, the engineering services department, the Raleigh Water Department, Parks and Recreation Department, et cetera. All those individual review team members review the plans, provide comment to the applicant on the deficiencies. The applicant's given an opportunity then to revise the plans and respond to the comments and resubmit. That process iterates until the plan is ultimately approved when comments are addressed or the applicant decides to not pursue the project.
And if there's a question along the way about the interpretation of a UDO term, are you sometimes consulted?
Yes, that's common.
Okay. And if that happens, is your decision the one that carries the day, if you will?
Yes.
Okay. What does a preliminary plat approval allow the applicant to do on the property once it's approved?
It doesn't authorize any work or construction on the property. It authorizes the applicant to move forward with the process and pursue the necessary permits and approvals needed to ultimately construct the infrastructure, record the lots, and build or transfer them.
Okay, so does a preliminary plat approval allow any construction,
No, it does not.
any buildings,
No.
grading?
No,
All of those things would require additional permits.
that's correct.
Okay. So does it even allow the creation of lots until, or is it just the starting point?
It's just a starting point. It's a kind of initial nod that says you may go ahead and pursue whatever you need to do to ultimately create the lots.
Okay, and what's final plat approval?
Final plat is the legal instrument that actually subdivides the land. It's once approved by staff, it gets recorded with the County Register of Deeds, and at that point, the lots can be transferred or built upon individually.
Okay, and when would a building be requested or a building permit be requested?
Not until after the final plat is recorded.
Okay, so this is, fair to say this is the first step in a multi-step process?
Yes, that's true.
Okay. So, what are the UDO infill rules?
There are a series of building setback, driveway setback, and building height requirements that apply in certain circumstances, generally in older established neighborhoods, older established lots, and requires compliance with a setbacks and height regulations that are based on adjoining property owners as opposed to what the zoning district requires.
And when are the infill rules applied in a project?
When a building permit is applied for any lot.
Do the infill rules have anything to do with the preliminary subdivision plat approval?
No, they do not.
Okay. With respect to the infill rules, do they apply if, in this particular subdivision, townhouse subdivision, there is a private road proposed, is that correct?
Yes, that's true.
Do the infill rules apply at all to private roads?
No, they do not.
Okay. All right, so now I would like to ask you some questions just generally about about the missing middle text change, because it's one of the sort of things that will be interpreted for the board to be interpreting through this appeal. When was missing middle 1 approved?
It was adopted in July of 2021.
Okay, and is it that particular text amendment that allows the townhouses at the density proposed in this plat?
Yes, it is.
And how many lots are proposed and what type?
17 townhouse lots and 1 open lot are proposed.
Okay, and this is just quick. Can you just kind of walk through the Raleigh text change process and explain to the board how text changes come before the Raleigh City Council?
Sure. There's 2 main ways where text change can, the process begins. Either City Council can direct staff to make a change to the ordinance, or a member of the public or a citizen can petition the council to authorize staff to make a change. And so that an application is submitted and that proposal is submitted to council, and at that time they decide whether to pursue it or not.
Okay, so can any text change move forward without council authorization?
No.
So it's kind of the beginning, starting point council, and then at the end council approval. Is that correct?
That's correct.
Can how was missing middle 1.0 initiated?
It's initiated through city council direction.
Okay, so that didn't originate in the plan. That was a direct city council request.
That's correct.
Can you kind of explain just quickly how that came up?
It came. The council at the time was very interested in ways to promote housing choice and affordability. They asked for staff to present some options as to how the UDO might be changed in order to accomplish that goal. Staff provided those options to the council, and they decided to move forward with them.
Okay, I am going to now hand you what's been marked as the city's Exhibit 7, and this is something that was already provided to the board at the last meeting. You have that. Can you identify that exhibit?
Yes, this is the TC 5-20 text change.
Specifically, what part, or what about the text change?
This is the minutes of the July 6, 2021 City Council meeting.
Okay. Wait a minute. I might have given you the wrong one. Where's my... I handed you the wrong exhibit. I didn't give you 7. There we go. Is that right? Right. Okay. No, we're good. This is the council. Okay. Just you can go ahead and use that one. Can you identify that?
It appears to be excerpts from the minutes of the July 6, 2021 City Council meeting.
Okay. And can you just look at those minutes and tell the board basically how what the purpose of some of the purposes of the missing middle changes?
The purposes of the ordinance itself. It permitted the townhouse building type in the R6 district as a conventional development option, in the R4 district as a compact development option, and in the R2 and R4 districts as part of a conservation development option. Permitted the attached house building type in the R2 and R4 districts as part of a conventional or compact development option. Permitted attached houses to be constructed on lots meeting the minimum dimensional requirements for a detached house. Reduced the minimum lot size for apartment building types where permitted. Reduced minimum site sizes for compact and conservation developments, and replaced those with minimum open space requirements. Removed minimum unit per acre density threshold and replaced those with site area or lot area per unit calculations. Removed the ground floor elevation requirements. It revised setback regulations for townhouses, and provided clarity by removing some outdated allowable building elements from the building type tables.
Which is the component that allowed the additional townhouse use or building type and density here?
It was the first one I read. Permit the townhouse building type in the R6 district as a conventional development option, in the R4 district as a compact development option, and in the R2 and R4 districts as part of a conservation development option.
Okay, and was allowing townhouses as a compact under the compact development option in R4, was that a specific direction of the city council?
Yes, it was.
Okay. And is it your understanding that the subdivision that is before the board today is the type of development that the city council was asking the code to be expanded to allow?
Yes, it is.
And how do you know that?
Because the subdivision we're discussing today is a compact townhouse development, and it is in the R4 zoning district.
I guess the question is, were you involved in drafting Missing Middle 1.0?
Yes, I was.
Okay. And so you were drafting that in reaction to the council's request.
Yes, that's correct.
So when you drafted it, is this what you intended?
Yes, it is.
This is what council approved through Missing Middle 1?
That's correct.
Okay. Okay, I'm going to hand you now, which is actually Exhibit A to your affidavit, so I'm not going to mark it as a separate exhibit, but I'm just going to ask you a couple of questions. I don't know if you have this or not. 7. Trying to keep straight on all of the days in the exhibit, so I apologize. Okay, can you tell the board what that particular document is?
This is the certified recommendation from the Raleigh Planning Commission to the City Council, and it's accompanied by the staff report for the text change TC 520.
Okay, and is that a document that is regularly provided to the city council when there's a proposed text change?
For every text change, it is provided,
Okay.
yes.
Okay, and there's two parts to it, is that right?
That's correct. There's a staff report and then the actual recommendation from the commission.
And the staff report, does that start on page 5?
Yes, it does.
Okay, and if you could, maybe turn to page 7. And does that, at the overview and purpose, does that kind of explain what you were just talking about, how the Missing Middle 1 came about?
Yes, it does.
And just quickly, it's the council asked the staff to bring back some options that would,
Council asked staff to bring back some options that would promote housing choice and affordability. Staff presented those options to the council in February of 2020. They accepted all those recommendations and actually expanded them to additional districts. After several months, staff came back to request clarification from council. That was in November of 2020. We provided recommendations at that time, and they were all approved.
and was adding townhouses under the compact option one of the council requested additions?
Yes, and that is listed on page 8 of the staff report.
At number 1?
Yes.
Okay, and then the first part of that, the Planning Commission recommendation, just quickly explain to the board what that is.
This is the Planning Commission certifying that they've reviewed the text change and that their recommendation to the City Council is that they approve it.
And that's required for every text change
Yes, it is.
under state law?
Yes.
And what was that recommendation?
It was that it was a unanimous recommendation for approval.
Okay, thank you. Okay, so, and then after it went to Planning Commission, it went to the council, correct?
That's correct.
And you've already explained the minutes and the council approval.
Yes.
Okay, thank you. Okay, if we could, we've talked a lot about the compact development option, and if you could turn quickly to slide 10. Just quickly, Mr. Chairman, I'm not sure we got the minutes, which was admitted Exhibit 7. Can we get that admitted?
Let's do that.
Thank you. Have a trusty helper here. Okay, so I'm back to where we are. So can you tell the board what that slide is on the screen?
This is section 2.1.2 from the UDO. It's entitled Housing Options, and you can see there are just some general descriptions of the types of housing options and development options that are permitted throughout the city.
Okay, and all of these are supplement 19, which is the big one that we admitted the last time. So there's conventional, compact, conservation, and those are the three options in residential districts?
That's correct.
Okay, and you don't have to read the whole thing, but just generally summarize for the board what the compact development option is.
It's a development option that allows, basically, permits smaller lot sizes, reduced setbacks, in exchange for a significant amount of open space.
And how long has that been a development option in the UDO?
It's always been an option since the UDO was adopted in 2013.
Okay, but just to make sure the board understands, the development option has been there, but the change from missing middle 1 was to allow townhouses to use that in R4 for the first time. Is that correct?
That's correct.
Okay. So if we could now turn to slide 11, which is another UDO excerpt that's in the record. And can you explain to the board what that particular UDO page sets forth?
This is the table of contents to the residential districts in Chapter 2. As you can see, there are some general provisions, and then for each development option, the individual building types that are permitted with each development option are included as part of those sections.
Okay, and is this the same basic scheme that has been in place since 2013?
Yes, it is.
Okay, so if someone, such as this applicant, was going to ask to develop townhouses in R4 under the compact development option, where would you go?
So first, you would go to Section 2.3.1, which are the general requirements for compact developments. There are some general requirements listed there. Following that, if townhouses were being proposed, you would look at the townhouse standards in Section 2.3.4.
And any other applicable UDO provisions?
Correct.
But these are the ones unique to that particular request?
Yes.
Okay. And 2.3.1 applies to every type of building?
Yes.
Type?
Yes.
All types of building types. And then you would go to the specific one for more specific guidance?
Correct.
Okay. You have you reviewed the 908 Williamson subdivision application and approval?
Yes, I have.
And I think you've said this, but one more time, what was requested?
It was a compact townhouse subdivision consisting of 17 proposed townhouse lots and 1 open lot.
Okay. And in your opinion, is that a use that is permitted by the UDO?
Yes, it is.
Okay. And are there certain UDO provisions that establish that the use is allowed pursuant to missing middle 1?
There are.
Okay.
Yes.
If you could, let's turn to slide 2.3. Slide 13. There's that page. Look at that. And that's the actual UDO provision that we were just looking at the table of contents. Is that right? Yeah.
Slide 12. Yeah, this is section 2.3.1, the general requirements for compact development.
Okay, so if you want to know how how does this govern townhouses specifically in D? What does that tell you?
So sections A through C apply globally to any building type. And then under subsection D, you can see the residential unit types, the maximum amount, and under the column for R4, 100% of the residential unit types are permitted to be townhouses in R4.
Okay, and so 100% of the buildings in this particular application are townhomes, is that correct? Or townhouses?
Correct.
Okay, if we could then turn to slide 15. Okay, and then when we had the table of contents up, you said that you would go to first to 2.2.3 and then to the specific provision that governs townhouses. Is that correct?
2.3.1 and then this provision, yes.
Okay, which is 2.3.4, which is compact development townhouses.
Yes.
Okay, and what does that tell you with respect to townhouse density?
As far as density is concerned,
Or explain to the board how density is calculated under the UDO.
sure. In this case, you would look at 2.3.4A, the site dimensions. A1 lists a net site area per unit minimum. And in R4, that unit minimum is 6,000 square feet. So for every dwelling unit on the property, there must be at least 6,000 square feet of land on the lot, or on
So
the site.
the math, if you will, you would take the total square footage of the entire site and then divide it by 6,000?
That's correct.
Okay, and if you do that with this particular application, what do you get?
17 and some change.
Okay. And then the width, that's the site width?
That is correct.
Okay, and is that 70, in this particular application, is that 70 lot width met?
Yes, it is.
Okay. Okay, so, Mr. Justice, if we could go real quick to slide number 17. And can you identify this particular provision?
This is section 1.4.2 entitled Building Types Allowed by District from Supplement 19 of the UDO.
Okay, and can you explain to the board what this table shows with respect to whether townhouses are permitted and under which situations in R4?
Sure. So in the the rows on the left under residential districts, you would go to the row titled Residential 4 and go over to the column titled Townhouse. That column has both an open square and a footnote. The open square tells you that the building type is allowed as part of an approved compact, conservation, or cottage court development.
Okay, and what about the footnote?
The footnote tells you that in R4 and R6, townhouses and apartments are also allowed as part of an approved development in the TOD overlay.
And does that mean that those both of those things are allowed, or they're separate? Are those to be read together?
They're to be read separately. Either of them can apply.
Okay. So
Mr. Chairman, this is just one of the running themes of a general objection. Occasionally I'll do it just
Okay.
to keep Frank
Fine, I think
awake.
that's good to do. Thank you.
All right, so if we could go to slide 18. Well, and I guess I could qualify him as an expert since the, well, Mr. Justice had an expert witness who testified to the meaning of these as an opinion for the board to consider, and we're doing nothing more but the same thing with a person with actual experience, so I'll just leave it at that.
Mr. Chairman, I'm doing what I need to do in terms of objection. I don't remember any objections when our witness spoke, but it is what it is. I'm just laying out a general objection.
Okay. All right, can you look at slide 18 and explain to the board what this is.
This is the current version of Section 1.4.2 that was part of Supplement 26 of the UDO.
And so when was that adopted? January, you look, it's at the bottom, you see the bottom? 2023,
I don't-
January 2023?
Yes, it was published in February of 2023.
Okay,
That's
published February 2023. Okay, and this table was revised, is that correct?
It was, yes.
Okay, and why was that?
It was revised to generally make it more clear and more for readability purposes, just recognizing all of the changes that have occurred since this table was created with the original UDO in terms of allowable housing options and patterns. So it was updated to reflect that.
And generally changed the format, if you will.
It did, yes.
And that's the table that's in effect today.
Yes.
And what does that say with respect to townhouses under the Compact Development District in R4?
Under the compact development option in R4, there's a solid black square. The key for the solid black square reads that the building type is allowed.
Okay, and if you could quickly move to slide 20. Okay. Okay, and under, I guess, if there is a discrepancy between a chart in the UDO and the text of the UDO, what controls?
The text of the UDO controls.
And why is that?
Because of section 12.1.2, it explains that the graphics, illustrations, charts used to explain visually certain provisions of this UDO are for illustrative purposes only, and where there's a conflict between the graphic, illustration, photograph, or flowchart and the text of the UDO, the text of the UDO controls.
Okay, thank you. Okay, if we could now turn to slide 11. Okay, so I would just go back quickly. So again, we're looking at the application and we're going to decide which sections to go to. And again, you go to 12.2.1 first, is that, or 12.3.1 first? Is that right?
2.3.1.
2.3,
Yes.
sorry. Okay, and that's slide 12?
Yes.
Okay. All right, so that has various sections that, again, apply to all compact developments, but also specifically to townhouses. Now, under Section A, what is that? It says site density. What does that apply to?
You can see that there's only, the only column with a number listed is in the R1 zoning district that caps the maximum density of 1 unit per acre. As I mentioned earlier, with the adoption of the Missing Middle 1 ordinance, the units per acre density caps were removed from the other residential zoning districts.
So it's as many as you can fit on there when you do that calculation with site size to lot size.
That's correct, yes.
Okay, so there's no density limitation at all in R4 for townhouses as long as everything else is met?
That's true, yes.
Okay, so if you look at the next section, which is open space in R4, what is that requirement?
In R4, the requirement is 20% or 1 acre, whichever is greater.
Okay, and what else? What about the width?
There's a minimum width of 50 feet.
Okay, have you compared that to the applicant's subdivision plat that was approved?
Yes, I have.
Okay, and if you go to slide 6 first, please. And what is that?
This is the site data table from the approved subdivision plan.
So that's just a part of the plan, but we pulled that one piece out.
Yes.
So you can read it. Okay, so does it set forth what the open space is?
It does.
Okay, can you walk through that with the board?
The second row from the bottom, it's highlighted, open space required, lists for a compact subdivision, 1 acre minimum, 60% minimum of that must be contiguous, and under that lists the type of open space tertiary that was provided, a total of 43,969 square feet, or 1.009 acres were provided, and 28,580, I believe, or 65% of that is contiguous.
Okay, so in your opinion, that requirement has been met by this plan?
Yes, it has.
Okay, and if we could go to slide 7. Okay, and can you identify that?
This is the subdivision plan in question.
Or at least one of the sheet CE 2.0. Does that show the open space on that particular page of the plat?
It does.
Okay, can you identify it?
Yeah, I can try to use the cursor if people can see it. There are 3 distinct open space areas demarcated. I think they are denoted by the gray, I believe it's a grid or dot pattern on the actual plan. That's hard to see here.
Okay, and each one of those has to be at least 50 by 50, if you will?
Correct.
And are each of those open space areas at least 50 feet by 50 feet?
Yes, they are.
Okay, thank you. Okay, let's go back again to slide 12, which is general requirements for the compact development. Okay, I'm going to skip C real quick and go to, we've already talked about D, and that says 100% of, okay. So let's look at section C. And there's been a lot of discussion about this, so if we could go to the next slide, which is slide 13, so it's easier to see, that is just that section highlighted, so it's more easily, the board can see it a little bit easier. Okay, there's a couple components to section C. How long has this been a part of the UDO?
Since it was adopted in 2013.
Okay. And have you been involved with subdivisions since you've been at the city that apply this particular section?
Yes, I have.
Okay. So you're familiar with it?
Yes.
Okay. All right. The first thing it talks about at C1 is the site boundary minimum. And what does that mean?
Refers to the boundary or perimeter of the site in question, and the minimum refers to the minimum width or minimum dimensions of what has to be around that boundary.
So the transitional protective yard, as that term is used there, is what's got to be around the whole site. Is that generally correct?
Correct.
Okay.
Yes.
And if you continue on to the rest of it, can you read or explain to the board the meaning or when it says what you have to do to meet the requirements of this particular section?
So for C1, there are 3 options provided. The first option would be to provide a type B1 transitional protective yard per section 7.2.4. Option 2 would be to provide a type B2 transitional protective yard per section 7.2.4. Third option would be that the perimeter lots meet the dimensional standards of Article 2.2, conventional development option of the district where the property is located.
Okay, and when you're interpreting the code, when you see the word "or," what does that mean to you?
It means that it is a choice or an option that refers to one or the other must be met, but not both.
As opposed to the term and what does that mean?
The term "and" would mean that both clauses would have to be satisfied.
Okay, so your testimony is that there's 3 options there, is that correct?
That's correct.
And if you were to pick the type B1 or type B2, what part of the code would you go to?
Section 7.2.4.
Okay, but what did this particular applicant elect to use?
This applicant elected to use the third option of providing a perimeter lot that met conventional dimensional standards.
And so how do you know whether those standards have been met? Where do you go to look for that?
Article 2.2, as stated here on the screen.
Okay. All right, and if you could go to slide 14. And that's, what part of the UDO, what does that govern?
This is section 2.2.6, and it governs the dimensions, setbacks, and other requirements for open lots.
And the conventional development option.
Yes, that's correct.
So is this where you would go to look to find those dimensional requirements?
Yes, it is.
Okay, and why would you use an open lot building type?
The lot in this instance does not propose any buildings. It's essentially accommodating open space and other elements of the plan, but no buildings are proposed, even though buildings are permitted on open lots.
Okay, so under R4, what are the dimensional requirements?
There's a minimum lot area of 10,000 square feet. There's a minimum lot width of 65 feet, and there's a maximum building coverage of 17%.
Okay, is the building coverage applicable here?
No building is proposed on the lot in question here.
Okay, so to satisfy 2.3.1C, if you're using the perimeter lot option, there are, under R4, these are the two requirements, is that correct?
That's correct.
Are there any other requirements at all with respect to that perimeter lot for purposes of a preliminary subdivision?
Not for the purposes of satisfying section 2.3.1C.
Okay, and if we go to, back to slide, we're going back to the slide with the, which I have in my notes here, slide 7. Does that set forth what the size of that perimeter lot is?
It does.
And what is that?
I can't read it here.
Here, you want to hand you I can hand you a copy of the plan. This is just a larger copy of the same.
So in the center of the screen in this white text box, it says that new lot 18 is 72,723 square feet, or 1.669 acres.
And the minimum is 10,000, is that correct?
That's correct.
Okay. Okay, so that provision, this plat has a perimeter lot in excess of 10,000 square feet.
Yes, it does.
Okay, so the second requirement is lot width. Is that correct?
Yes.
And how is the lot width measured?
Lot width is measured at the street frontage of the lot. It's the distance between the side property lines.
Can you pull up slide 16, please? And does the UDO tell whoever, an applicant or the staff, how to measure lot width?
Yes, section 1.5.1C. It says that lot width is the distance between the side lot lines, generally running perpendicular to a street, measured at the primary street property line, along a straight line, or along the chord of the property line.
Okay, and is that universally the way that you measure lot width anytime it's required in the UDO?
Yes, it is.
And so that's, so it's always consistent as how you take the measurement?
Yes.
Okay, so for purposes of this particular application, if you could turn to slide 8, and I can give you a bigger copy of it. You got it up. Where is it? There it is. Okay, there you go. And can you just identify what page that is for the approved plat?
It's sheet LA-1, identified as the landscape plan.
Okay, and does that have the lot width on it?
It does.
Okay, and for purposes of determining lot width for preliminary subdivision plat, perimeter lot, which street do you measure?
At the primary street, which in this case was Williamson Drive.
Okay. For purposes of this particular application, what is the importance or the relevance of designating a primary street?
With respect to this preliminary subdivision plan, the only importance of the primary street is to identify that whether the minimum lot width of this lot has been satisfied.
And what is that lot width at Williamson?
The plan shows the lot width at 321.6 feet.
Okay, so that's well in excess of 65 feet?
Yes, it is.
Okay, and assuming just for purposes of argument that the primary street was Iredale, what is the lot width there?
On Iredale, the lot width is listed as 271.5 feet.
Okay, so that would be met as well?
Yes, it would.
So with respect to which street is a primary street for purposes of this application, does it matter?
No, the lot width is satisfied and then some on either street.
Okay. Did you review the appellant's, well, you heard the appellant's expert testify, is that correct?
Yes, I did.
And reviewed his affidavit?
Yes, I did.
And he had an opinion that the lot width was not met in this case, is that right?
That's correct.
Did he measure the lot width according to the UDO rules?
He did not, no.
Okay. So he just measured from wherever width it was on the entire site? Is that what he did?
I believe his testimony and affidavit claimed that because the lot tapered and was not 65 feet wide throughout its entirety, that it did not comply with the dimensional requirements.
Okay. Now, are you aware that there were some questions asked during the application process by the developer and some of your staff about whether this option was available for a townhouse compact development to use a perimeter lot as opposed to some other transitional protective yard?
Yes,
Okay. And were you consulted about that?
I was.
Okay. And what was your response when you were asked that question?
My response was that it could be that a perimeter lot meeting the conventional development standards of an open lot in the R4 district could satisfy 2.3.1C.
Okay, and I'll get back to this in a minute, but has that interpretation been used in other cases throughout the years?
Yes.
Okay. But it wouldn't be for townhomes, right?
Correct. This is given the newness of the regulations. It hasn't been applied to townhomes in the past.
Exhibit 8. Okay. You also have heard some questions or argument that if you use this third option, if we can go back to 2.3.1, the blow up of it. Yeah, right there. That if this option is used, that there has to be more than one lot. Is that correct?
That's correct.
Okay, do you agree with that?
I do not.
And why not?
It's my opinion that the word lots refers to both the singular and the plural of lots.
Objection. General objection, Mr. Chairman.
Okay, I'm going to hand you now what's been marked as the city's Exhibit 8. And ask if you can identify that.
These are excerpts from the UDO. Supplement 19, that highlights numerous provisions throughout the code where the term lots is used in its plural form.
Okay, and in using the UDO and interpreting the UDO, do you often have to interpret or use the word lots?
Yes, it's a frequently used word.
Okay, can we get that admitted? It's an excerpt of
Yes, you may.
what's already there. Okay, just for a couple of examples, put it this way: if you required every reference to the word plural lots in the UDO to require more than one, could you reasonably even interpret the UDO?
No, it's my opinion it couldn't be applied.
Okay, let's just use some examples. On page 1-11, where it talks about measurement, it says, in lot width, we've been talking about lot width. It says a lot must meet the minimum lot width for the entire minimum depth of the parcel except for cul-de-sac lots. How do you interpret that? Do you have to have more than one cul-de-sac lot?
No, it would apply to any individual cul-de-sac lot.
Is there a reference to the plural cul-de-sac lots throughout the UDO?
Yes.
Okay, another plural, if you go to page 1-14. Setback types, it talks about through lots, reverse frontage lots, and adjacent lots. Does that include only more than one lot, or would you apply that setback provision to a single lot?
You would apply it to a single lot as well.
Okay, another example, multiple street frontage lots, later on that page.
Yes.
Same interpretation?
Same opinion, same interpretation.
Okay. We would just like to have this admitted and as, Exhibit 8 to show the word lots throughout the UDO. Okay, when you do interpretations, we had a page up a minute ago where the UDO tells you, and we can go back to that page real quick, sort of what you use when you are interpreting UDO terms. Which is slide 20. And as a zoning administrator, you use general rules of interpretation such as this when you are trying to decide the meaning of a term. Is that right?
Yes, I do.
Okay, and under C, it allows you to look at rules of interpretation that are used for state statutes. Is that correct?
Yes, that's correct.
And generally, those are the principles of construction that you use pretty much whenever you're interpreting. Is that right?
Yes, they are.
Okay. So if we could turn real quick to slide 19. And do you recognize this? Is it a state statute that applies to construction of statutes
Yes, I do, and yes, it is.
that you use for ordinances as well?
Yes.
And can you just briefly or read or explain to the board what that says?
It says that every word using the singular number only shall extend and be applied to several persons or things, as well as to one person or thing. And the bold underlined portion reads, and every word importing the plural number only shall extend and be applied to one person or thing, as well as to several persons or things.
Okay, and just quickly to kind of end this line of questioning, we just looked at the lot width and lot dimension requirements for the perimeter lot, correct?
Correct.
And they were well in excess of the requirements.
Correct.
Would it be possible to turn this one lot into two? and still meet the requirements?
In my opinion, that could easily be done.
Objection, Your Honor. Anyway, objection.
Thank you.
There's enough land area and other dimensions that would satisfy the creation of 2 lots, in my opinion.
Okay, I'm going to hand you now, can I have Exhibit 9? What's been marked as the city's Exhibit 9? It's not stapled, but. And ask if you can identify that.
This is the approval documents for a subdivision called Barwell Park Subdivision with a file number of S-46-2016.
Okay, and who was the reviewer of that particular plan?
I was.
Okay, can you pull up slide 21, please? Okay, and that's that approved subdivision, compact subdivision?
Yes, that's correct.
This is prior to missing middle 1, correct?
Yes, it is.
Okay, and can you explain to the board whether the perimeter lot option was used in this section to satisfy 2.3.1C?
It was not. You can, the perimeter lot option was used. So you can see there's no transitional protective yard required because the lots around the perimeter of the subdivision satisfied the conventional lot dimension requirements.
Including is there an open lot there?
There is one open lot on the eastern or far right side of the plan.
And that's,
I'm sorry, 2 open lots.
okay, and
Yeah.
that's the same interpretation as was used in this particular case, is that right?
That's correct.
Okay, can you turn to slide 22? And what does that note 8 say?
Note 8 states that perimeter lots meet UDO 2.2 conventional development option of the applicable zoning district.
Okay, and this was in 2016, well before missing middle 2.
That's correct.
Okay. Can we move to admit that, please?
Yes.
Okay, let me have the Exhibit 10. I got it. I'm going to bring these both to you at the same time, Ralph. I'm going to hand you what's marked as the city's Exhibit 10 and ask if you recognize that.
I do. This is the administrative approval for a subdivision called S-17-14, Windcrest Compact Development Subdivision.
Okay, can you put up 23, please? Okay, and is that that subdivision plat that was approved pre-missing middle 1?
This was approved prior to missing middle 1.
Okay, and is the perimeter lot used there to meet 2.3.1C?
Yes, it is.
And can you show the board real quick where that is?
Sure. There are, most of these lots are perimeter, but here is a perimeter open lot. These lots are perimeter building lots.
Okay, can we go to the next slide? Okay, and this is project data from the same sheet, just blown up. And can you point out to the board what kind of lots were approved in this compact subdivision?
17 single-family residential lots and 1 open lot in 1 phase.
Okay, and is that coincidentally exactly the same as 908 Williamson?
It is.
Okay. Okay, just a couple other questions. Oh, sorry, can we admit that as well, please?
Yes.
Exhibit 10.
Exhibit 10.
Okay, and I'm not going to go through every single requirement, but those are the ones I think there were some questions. There is also a tree conservation requirement for a compact subdivision, well, basically any subdivision, is that correct?
Any subdivision on lots that are greater than 2 acres in size, yes.
Okay, so a tree conservation area was required.
Yes, it was.
And can you explain what tree conservation means as opposed to a TPY?
Tree conservation regulations exist to preserve existing stands of healthy trees. So it is a requirement that requires the preservation and perpetuity of certain stands of trees that meet the code requirements and that can't be removed as part of a development.
Okay, if you could go to slide 9. Okay, and is that the page of the plan that addresses tree conservation?
Yes, it is.
And does it state on there what's required and what was provided?
Yes, the plan sheet states that 10,542 square feet of tree conservation area was required and 10,552 square feet were provided.
Okay, if I could just have 1 second, I think I'm almost done. Okay, well, just basically one more question that relates to the appellant's expert. You listened to his testimony, is that correct?
Yes, it is.
And reviewed his affidavit.
Yes, I did.
And do you agree with his testimony?
There were a number of pieces of his testimony I did not agree with.
Okay, do you remember what those were?
One was the applicability of the infill setback regulations to this subdivision plan. I disagree with his determination of the primary street of this subdivision plan. There was a claim or statement that townhouses and attached houses are the same thing when they are in fact 2 distinct and separate building types in the UDO.
Explain to the board what an attached house
It's
is.
essentially a duplex, 2 dwelling units in 1 building.
And so duplexes are attached and townhouses are different and they're regulated differently?
Yes, that's correct.
I think you spoke to lot width measurement.
Yes, measurement of lot width with his method was not how the UDO prescribes that measurement to be taken.
And what about the interpretation of that if the word lots appear, it only applies to if there's more than one?
As I testified, I disagree with that as well. Yeah.
Okay. Anything else you can think of?
No.
Okay. I guess to sum up, so having reviewed the plan and all of the applicable UDO provisions, if you were to review this as the zoning administrator and you do not believe that it was erroneously approved, is that correct?
That is correct.
Okay. You have no questions? Okay, I don't have any questions.
Other questions?
Thank you. Mr. Justice, before we turn it to you, we're going to take a short recess, 10 minutes, please, and then we'll come back and it'll be your opportunity. Thank you, Mr. Romero. And we'll welcome you to take over.
Good morning, Mr. Romana. Can I call you Justin?
You can if it's easier than pronouncing my last name.
A little bit easier. So this was Exhibit 6 of our exhibits, appellant exhibits, and this was a graphic depicting really what makes up Lot 18. You see that? And that everything in color, be it black, pink, orange, made up this Lot 18. Do you see that?
I see it.
Do you disagree with the boundaries of this or what it depicts?
No.
You mentioned Lot 18 is 1.66 acres, and so that acreage would include what's in the middle there, that's orange. It would include what's in pink, and include the road that's hatched in black, correct?
That's correct.
So looking at this as one, and I'll call it an HOA lot, or one common lot, where you have here the road is approximately, according to this, the retaining wall and road is about 5 feet from the perimeter boundary. What is a comparable development that you were involved with approving that allowed for one HOA lot to suffice for purposes of being a perimeter lots?
Repeat the question.
Do you have one example, other than Williamson, where you allowed one HOA lot to suffice for being perimeter lots in section 2.3.1?
A singular lot, is that what you're asking?
Yes.
I haven't reviewed or approved a plan in over 5 years. I'm be happy to go look for some. I don't know of any off the top of my head.
Well, I think the board will attest. We have been at this several months, and I have asked this very question of Daniel last go around.
Objection. The question is not what has been approved, but whether this follows the provisions of the UDO itself, not what happened in the past, but whether or not the objective requirements. So I don't think he's got an obligation to go dig through every plan to find something to answer Mr. Justice's question.
Mr. Chairman, I find that ironic. I think Frank, was that Exhibit 8 and 9? Was that two other subdivisions?
Exhibit 10, Exhibit 9.
9 and 10 was something they dug out of some files. So I'm just asking, for purposes of comparing this Williamson property to any project that you are aware of, and you can say, I'm not aware, is there another project out there where the city allowed one HOA common lot to suffice for being perimeter lots for compact subdivision 2.3.1?
I'll just
To
say,
your knowledge.
I'll just say, to my knowledge, the exhibits provided earlier were found during the last meeting. They were the first two that I found because there was discussion about them. I didn't look any further. And it's my opinion that whether there is one lot or two lots, as I testified, is not relevant, and so I therefore did not dig or look for anything further.
So what I'm hearing you said the first two files you put your finger on that dealt with compact development, you found something that would match up with your interpretation?
Those were files where perimeter lots were used without a transitional protective yard, because at the last meeting, much of your argument and much of your appeal focused around the requirement that there be a transitional protective yard.
Well, we're going to get into the two examples in a little bit, but let's, you said you've been with the city since 2013, correct?
Yes.
And during that period of time, the requirements associated with a transitional protective yard, where it, as you say, it provides three options: putting a B1 or B2 vegetative buffer or perimeter lots, that language has been in place since 2013, right?
Correct.
And that language was applicable to conservation developments, right?
Believe so.
And you were here for the last hearing, right? You've been here for every hearing, correct?
Correct.
And you saw that the minimum site requirements for a conventional development was 12 acres?
It may have been originally, yes.
All right. And then for compact developments, prior to Middle Housing 1, the minimum site requirements for compact developments were for R4. Was it 8 acres?
That sounds correct, yes.
Okay. And so at the end of the day, with middle housing 1 changes, did the city council change section 2.3.1, the section that dealt with transitional protective yards for R4?
That 2.3.1C, if that's the section you're referring to, did not change, but it applies in all zoning districts.
Madam Court Reporter, I had in my notes that I left off with Exhibit 33. So based on those listed exhibits, Mr. Chairman, I believe I'm at Exhibit 34. So I'm going to mark mark this as Exhibit 34A. This other one is Exhibit 34B. Yeah, 1 second. So Exhibit 34, I don't know if you remember, we were pulling from just sort of historical ordinance language to prove the point that some of the language never changed with middle housing 1.
Mr. Justice, please, you need to use the microphone.
We were looking at Supplement 2, which is from 2013, and Supplement 12, which was just prior to the middle housing 1 changes. So if you look at Exhibit 34A, is that several code provisions from Supplement 2 of the City of Raleigh UDO.
Yes.
And then Exhibit 34B is several code provisions from Supplement 12 of the City of Raleigh UDO, correct?
Yes.
Okay. Mr. Chairman, I'd like to hand up to the board Exhibits 34A and 34B.
Okay.
I'll hand up Exhibit 34A first.
Yeah, 2 and 12.
I've only got two of the same thing.
Look at the bottom.
Bottom left.
2 and 12.
Oh, yeah, okay, I got it.
No, we need 12.
Oh, yeah, we got 2 twos.
I'll fix that in a second. Robin, what are you missing?
Well, I have 2 supplement 2s that say exactly the same thing.
Hand me one of the twos back. Thanks. So what I handed to you for Exhibits 34A and 34B show that for conventional development options, when you're talking about a detached house use of a lot or an open lot use, or for compact development general requirements, that those standards remain the same from essentially September of 2013 up until mental housing number 1. Is that a fair statement?
Or for all building types, I'm sorry?
Yeah, I'm just saying that I've included section 2.2.1, section 2.2.6, and section 2.3.1, and I've given you the version from Supplement 2 that was in effect in 2013, and Supplement 12 that was in effect just prior to the Middle Housing 1 changes. And those sections haven't changed in the years between 2013 up until the Middle Housing 1, right?
They appear not to have now.
Okay. All right. Justin, I'm going to go over some of the exhibits we've used before. Mr. Chairman, I assume all the board members have the exhibits that we've provided previously. Hearings.
We should, yes.
Okay. Justin, I'm going to show you this is Exhibit 17, our Exhibit 17, which is a set of minutes from a Healthy Neighborhoods Committee report in 2000, or meeting in 2019. And there was a discussion about the intent for transition protective yards, and that the intent of TPYs was to protect neighborhood character. You see that? This is something Daniel went over.
I see it, yes.
As you sit here
And
today,
I'll just renew my objection because it's very old and not relevant to the current missing middle.
none of this language appears to be relevant to the city, but I'm just wanting you to realize there is certain relevancies to a transition protective yard and its purpose. This document says the intent of the TPYs is to protect neighborhood character. So I was going to ask you, you've been a zoning administrator since 2020. You said you started with the city, I think, in 2013, is that right?
Yes.
You didn't really, you said you were involved as a planner. Can you be more specific in what your roles were from 2013 to 2020?
2013, I started with the city as what was called a Planner 2. My responsibilities included reviewing site plans, subdivision plans, presenting plans to the Planning Commission. I was subsequently promoted to a planning supervisor. I managed a group of planners at that point who was doing the work that I was previously doing. Subsequent to that, I was promoted to the current planning manager position, and until 2020, I managed all of the planners who were responsible for issuing zoning permits, site plan and subdivision approvals, as well as zoning inspections.
Okay. So from at least since 2013, you've had your finger in being involved in site plans, subdivision development approvals in one capacity or another, right?
Yes.
All right. So from your experience, do you have an opinion as to whether or not this statement is correct or not, that a transition protective yard is intended to protect neighborhood character? Do you have an opinion either way?
I have an opinion that there are other reasons to have a transitional protective yard, but
Okay.
I don't disagree with the statement.
What would be the other reasons?
Landscaping is commonly used to attenuate noise, to provide visual benefits. It's a common requirement throughout zoning codes.
So the other things you talk about providing, they're essentially an aesthetic or acoustic buffer for adjoining properties.
Correct.
And that,
If I could just object again, just to follow up on Robbins, that the discussion in these minutes from 2019 is about.
Michael, please use the microphone.
Thanks. The objection relates to what Robin said, but just to highlight again that what Craig is asking Justin about relate to committee minutes from 2019 where they are discussing neighborhood transitions, which is a specific type of transition, neighborhood transitions between mixed-use districts, which allow non-residential uses, and residential districts, where these neighborhood transitions are required. That is different than the type of transitional protective yard that's referred to in the for a compact subdivision. So I just want to highlight again the lack of relevance of this question.
Mr. Chairman, that's Michael Spinn. He's an attorney. He's making an argument. It says the intent of TPYs is to preserve neighborhood character. It says what it says. And I was just asking the witness whether he disagrees. And in fact, he expounded upon it by saying, oh, it provides acoustic buffers and aesthetic buffers. I'll move on. And then in Exhibit 18, there's a statement here about why include transition yards between townhouses and single family. And it says the intent is to soften impacts and concerns to adjacent single-family homes, right?
That's what this email says, yes.
Do you disagree with that statement? Or have an opinion?
I would just say that was a email from a planning commission member who ultimately voted to remove and not have that requirement.
Yeah, voted to remove it, and I think the board needs to be aware of the statement you just made. They removed the transition protective yard criteria for R6 zones, right?
They recommended that the council do it, yes.
And council did do it, right?
Yes.
But the council maintained the transition protective yard requirements in 2.3.1 for R4 with townhouses, yes?
They preserved that as one of the options as complying with 2.3.1.
They didn't, for townhouses in R4, they did not change the requirements of 2.3.1, whatever you say they may be. They didn't amend that section for townhouses in R4.
They did. If you're referring to 2.3.1C, they did not. 2.3.1, they did.
By saying that townhouses can be compact developments in R4. Is that what you're
That every dwelling unit in a compact townhouse development can be a compact development can be a townhouse.
Okay. All right, so let me show you communication, Exhibit 20, communication. This is March 17th, 2022. This is Keegan McDonald in a chain of communications between Keegan McDonald and Jason Meadows. And you see there on March 14th, 2022, Jason Meadows is asking Keegan McDonald and Eric Hodgej really what is one of the primary questions that's before the board, right? About whether or not a singular common HOA lot can suffice for purposes of section 2.3.1C, correct?
Yes.
And the answer from Keegan was no. At this time, right?
Yeah, the answer was that no, a townhouse lot could not be used in R4 at that time.
Well, the question posed was, can a singular HOA lot of, heck, the dimensions we showed, we're not even getting into that, but a singular HOA lot, can it suffice? And the answer is no, right?
Yes, because there were no lot dimensional standards for townhouses in R4 at that time. That's what the response was.
Yeah. So at this time, Keegan is not saying, well, an option is to do what you want to do at this time, right?
I'm going to object. He's not on this email at all, so he's asking him to think about what one of his employees was communicating with another person.
He testified he had communications. I'm about to leap into all that, but it's certainly... Did you review the correspondence between Keegan McDonald and Jason Meadows when you were considering the question of compliance with 2.3.1 for this development?
I believe I did. I was on paternity leave at the time that those emails went back and forth, but when I returned to the office, I believe I did.
Well, congratulations on the paternity leave.
Thank you.
All right, I'm going to show you what I mark as Exhibit 35. Now, Exhibit 35, these would be City of Raleigh public records dealing with development project that has a label of SUB-S-23-2015, right?
Yes.
And this is for a compact subdivision in a conditional use district, residential 4, and conservation management, right? Called Suncrest Village.
Correct.
And it lists you as the staff coordinator.
Is that a question?
Right, you are the staff coordinator in this?
Yes. Yes.
Mr. Chairman, I'd like to introduce Exhibit 35 into the record.
You may.
In this, one of the conditions of development approval was for the developer, and there's a note here that says, prior to issuance of building permits on lots 8 through 15, the required type B1 transitional protective yard plantings shall be shown on the plot plans for each lot. Is that right?
Yes.
So this development is an example of a development where transitional protective yard compliance is an issue, and this particular developer is using vegetative buffers to satisfy the standard of the ordinance, correct?
That appears to be the case, at least on a portion of the property, yes.
All right, I'm going to show you what I'll mark as Exhibit 36. Exhibit 36 is a City of Raleigh public record for a development called Brinley, B-R-I-N-L-E-Y, Subdivision. And this is a conservation subdivision that was applying for conservation development approval, right?
I see that it's called Brinley Manor. I can take your word for it, but I don't see where it says it's a conservation development.
All right, let me show you what I mark as Exhibit 37. Exhibit 37 is additional City of Raleigh public records relating to the Brindley subdivision. Is that correct?
Yes.
And this is a development from 2016 that was asking approval under the conservation development standards of the UDO, right?
Yes.
And for conservation development, again, just a reminder to the board, isn't it right, Justin, that the issue of transition protective yard, B1 or B2, or perimeter lots, that standard would be applicable for this development, right?
Yes.
Mr. Chairman, I'd like to introduce Exhibits 36 and 37 into the record.
Okay.
For this development, the standard that dealt with either B1 or B2 vegetative versus perimeter lots, or the third option, perimeter lots, the developer chose in this instance to put in conventional perimeter lots, right?
Yes, they did.
So this is a blow-up of Exhibit 36. And if you look in the left-hand side, well, let's just walk through this development. For conservation development in this district, it's showing the lots in sort of the interior, if you will, to be less than 10,000 square feet, correct?
Yes.
And for R4, this was in R4, the standard conventional development size for lots is 10,000 square feet. Yeah?
Yes.
And so here the developer is wanting to pack in smaller lots in the interior, and they're all noted here in white on this exhibit. And then on the periphery, the developer is putting in lots that are 10,000 square feet. Yes?
Yes.
And in fact, there's a note here on this plan that says periphery lots to meet dimensional standards of UDO Article 2.2, conventional development option of the R4 district, no transitional protective yard required. And that's because at the periphery, the developer put in conventional lots along the periphery, right?
Yes.
I give it to you. There you go. So just to recount, we've been over two developments so far. One's a compact and one's a conservation, where the developer is showing compliance with the perimeter concerns by either doing a vegetative buffer, that was the first case we looked at, or in the second case, where there were conventional perimeter lots around the perimeter, correct?
I would just say that with the first case, they used both options in tandem.
Okay. All right, let me show you what I mark as Exhibit 38. Exhibit 38 is City of Raleigh public records dealing with a development application and approval for an Elmwood subdivision in 2016. Is that right?
Yes.
And this is a compact subdivision at this time in R6, right?
Correct.
Mr. Chairman, I'd like to introduce Exhibit 38 into the record.
Exhibit 38.
Now, who's Michael Walters?
He is a planner for the city.
And throughout his comments, so if you take the first page and you walk back through it, and by the way, the first part of this exhibit, these are staff, what do you call these, staff review notes or comments?
They appear to be comments, yes.
And then ultimately attached to this exhibit is the administrative approval action, right?
Yes.
And so if you look in these comments, the topic of transitional protective yards or perimeter conventional lots is being addressed on several occasions, like if you go from the first page into the document on the fourth page, you see Michael Walters saying 2.4.1C1 requires either a B1 or B2 transition protective yard or conventional lots meeting conventional standards along the perimeter. And then he goes on to say it can be open space and transition protective yard concurrently. You see that?
I do.
So the way I read this, Justin, is he's saying that it can be open space around the perimeter, but it has to be a protective yard transition, which would be either the B1 or B2 buffer. That's what I read that comment to say. Is that a fair reading of that comment?
Seems fair. I would. I read it as Michael saying that the along the perimeter, the open space and the transitional protective yard can overlap. But I have no way of knowing what exactly he meant.
Well, if you turn after page 4, if you go further into the staff notes, the 5th, 6th, 7th, 8th page, you'll see a comment that's labeled Sequence 9, dated May 5th, 2017. Do you see that at the bottom of the page?
I do.
He says, for clarification, please provide diagram demonstrating compliance to 2.4.1C1. Now, that section would be for the R6. That would be compact development for R6, right? Do that would still have that language in there about B1 or B2 or perimeter lots, right?
Yes.
And he says label the TCA, that's the tree conservation area, right?
Yes.
Transitional protective yard. And then he goes on to say, if not proposing minimum 6,000 square foot lots, perimeter lots are all lots that share a front, side, or rear property line. Now, the minimum lot size for R6 at that time was 6,000 square feet.
I believe so.
So he's saying if not proposing, he's talking about the fact that the perimeter lots need to be conventional perimeter lots or a transitional protective yard with buffers, right?
Appears to me that's what he's saying.
Did I give you that? Those exhibits? Did I give it to you? I got it. All right, I'll show you what I mark as Exhibit 39. Exhibit 39 would be City of Raleigh Public Records dealing with a development application and approval of a subdivision called Barwell Park was applied for in 2016. Is that right?
Yes.
And this is a approval for a compact subdivision, right?
Yes.
Mr. Chairman, I'd like to introduce Exhibit 38 into the record.
This is 39, I believe.
39, my apologies.
That's okay.
Justin, did I mark that 39 or did I?
You did.
Okay, great. That's Frank's fault. Now, this particular project, you had your hands in this particular project, is that right?
I was the coordinating planner.
And then you have a note here for Barwell, this particular development. It's sequence number 12, so if really it's easier to start from the, well, if you start from the first of staff comments, it's page 1, 2, 3, 4, 5, 6 pages in. Sequence number 11, sorry. Your comment here is several of the perimeter lots do not appear to be meeting the dimensional requirements of conventional subdivision. In those cases, the type B1 or B2 TPY would be required. Is that right?
Yes.
So this is the one where you brought up as an example of, you're saying that a perimeter lot was satisfied by a common lot. You pointed to this as an example, right?
Again, it was an example where conventional lot or lots were provided in lieu of a transitional protective yard.
All right, so let's look at so if we go into the plan sheet for this, which is part of the administrative action approval documents, there is a subdivision plan. Do you see that?
I do.
Where is the common open space lot that you say is an example of your interpretation for Williamson?
So again, one more time, these were examples where a transitional protective yard was not required and was not provided. But if you're asking about common lots on this plan, which was not the purpose of me providing this example, there's a common lot 109 and there's a common lot 108, and both are on the perimeter, or at least portions of the perimeter of the property.
So let's just break down what you just said. You use this example to say, well, along the perimeter here, there's not a vegetative buffer of a B1, B2 type, right? Where lots 108 and 109 are, correct?
Where any lot is.
Well, let's go around the whole perimeter. Let's start at the top of the page is north, so to the left is the west. So I see lot numbers 68 through 74. So are those all conventional developable lots where you would put a structure?
Yes.
Okay. So looking at the top of the page, north, lots 68 through 51, the same question. Are those conventional detached lots?
Yes.
So I guess for purposes of something that's not a conventional detached lot, satisfying, because these are for detached homes, right? This development.
They are.
So where is it on this plan that you're saying, well, that's not a conventional detached house lot, but it suffices for purposes of section 2.3.1? Is that, you said that was lots 108 and 109?
Yeah, again, that wasn't my purpose in providing this example, but yes, that would be my opinion.
Okay, so I'm looking at all these notes for 108 and 109, and when you drill down and look at all those notes, there's many references to that area being a TCA. Yes?
Is that a question?
Well, there are many references within the body of what's labeled 108 and 109 where there's multiple references to a TCA, tree conservation areas.
There are portions of both of those lots that appear to be tree conservation area. I can't tell on the small print whether the entire lot is or not.
What is the width of 109?
The width of the lot?
Yeah.
It's not dimensioned here, but it appears to be several hundred feet.
Several hundred feet. So between where the smaller lot sizes, so let's just take lot 49. So is 49 a compact lot?
49 appears to be a conventional lot.
All right, so where is a compact lot here?
Any lot that's in the R6 portion of the property that's less than 6,000 square feet, or in the R4 portion of the property that's less than 10,000 square feet. So 37, 95.
37. So that's into the interior. What else? 25 or 95?
If 95, I can't see the zoning line clearly on here, but
But
if 95 is in the R4 portion, then that would be a compact lot.
that's in the interior, right?
Yes.
So R4 is to the left of the page. It's more of the western part.
Yes.
And all the R4 perimeter lots are 10,000 square feet, right?
Appears that way.
And then you come over here to the right-hand side, that's R6. Is that right?
That's right.
And you basically have, is that the does that say Neuse River along that boundary?
What boundary?
Along the eastern boundary.
I think you're referring to Neuse River riparian buffer, 50-foot Neuse River riparian buffer.
Yeah. So you've got, along the east side, you've got a riparian buffer of at least 50 feet?
They're measured 50 feet from the bank of the stream, yes.
So riparian buffer, this is an area you can't disturb as a developer, that you need to maintain its vegetative state for purposes of protecting the waterway that is there, right?
Generally, yes. I'm not an expert on the buffers, but there are.
So generally, yes. You gave us two examples after several months of asking about, give me comparables, what you've done to Williamson. One of your comparables is staring at lots that are labeled 108 or 109, where within the body of the lot, there's a riparian buffer of a preserved vegetative corridor of 50 feet. In addition to the fact you just got through testifying that those lots are generally 200s of feet wide, right?
Objection, are
No.
you're talking about a tree conservation area? Is that what you're talking about?
If
You're
Robin, if
characterizing-
you
I'm
have
just
a
objecting
confusion-
at the characterization of it as a TPY or a buffer when it is something different.
Oh, well, it's all in a name. I'm just looking at what is on the piece of paper. What is on the piece of paper to the what you were saying is, see, we didn't do a transition protective yard along the lots 108 or 109. That was your example. Those lots consist of riparian buffers, right?
The lots do, but again, I know I'm sounding like a broken record here. The purpose of me providing these examples was to counter the statements from the last hearings that a transitional protective yard is always required. That was part of your appeal, and that was stated at the last meeting. The purpose of providing these plans clearly shows that a transitional protective yard is not always required. It is one of three options that an applicant can choose in order to comply with Section 2.3.1C. That was the sole purpose of providing this example and the other one. In fact, I didn't even look at lots 108 and 109. I was referring to the other lots, the building lots around the perimeter of the property.
Well, I'm sorry. The other lots around the perimeter of the property are conventional size.
Correct.
Okay. But for purposes of 108 and 109, what is to the east of this property? Is there actually a development or residential lots to the east? Do you know?
I don't know.
Okay. What we do know is that for this development, around the periphery, except for the east side, are conventional size lots. Yes?
I'm sorry, repeat that?
Around the periphery, the perimeter of this development, on all sides except for the east, are conventional size lots, right?
I don't know about all lots, but a large portion of them are.
Okay. And then ultimately on the east side, for lots 108, 109, there's a mix of tree conservation area and riparian buffers, right?
Those are elements that exist on lots 108 and 109, yes.
And as to your comment about perimeter lots, the one comment you had about perimeter lots is they do not appear to be meeting the dimensional requirements of a conventional subdivision. In those cases, the type B1 or B2 TP wide would be required. That's what you said for this project. Yes?
Yes.
Okay. All right, I'm going to show you what I marked as Exhibit 40. Exhibit 40 is a set of City of Raleigh public records dealing with a development application and approval for a development called Homestead at Leesville Reserve. Is that right?
Yes.
And this is for a R4 zoned piece of property, and this is a compact residential subdivision, right?
Yes.
Mr. Chairman, I'd like to introduce Exhibit 40 into the record.
Exhibit 40.
If you turn into the staff notes, if you go basically staff notes, you can start from the back and go to the second page. There's a number of references here to perimeter conventional lots or the perimeter buffer. If you look at sequence number 14, staff comment from Mr. Walters, do you see that where it says, as a compact subdivision, required conventional lots or buffer along perimeter, and it cites to 2.3.1C?
Yes.
And if you look then at page 3 of this document in sequence 2, there's you see a comment that says lots 18 and 22 are perimeter lots, thus either need to meet minimum standards of a convention R4 lot or a compact lot with B1 or B2 transition protective yard. You see that?
Yes.
So with this development, just like all the other ones we've so far looked at, so far the standard, or at least the choice that's being made and accepted by the city, is either a conventional developable lot for a structure or the vegetative buffer, with the one exception of Barwell along lots 108 at 109, where there's this riparian buffer and conservation area, right?
No, again, as I stated earlier, the Exhibit 35, S2315 provided both a transitional protective yard and a conventional lot that is not a building lot around the perimeter of the property.
Wait, Exhibit 35, which development was that?
S23-15 Suncrest Village, Phase 4.
Actually, you didn't say anything about that. So where is it that you're saying, let me just be sure I understand what you're what you're now testifying to is you're saying that there is a is there a lot around the perimeter that is an open lot that doesn't have a buffer?
Lot 17 appears to meet that criteria, yes.
Where's lot 17? Oh, how big is lot 17?
I can't read it. Looks to be, I can't even attempt to see what that says.
Do you know where the tree conservation areas are on this plan?
I can't tell from the,
And in fact, what that lot you just pointed to, that is another example of a riparian buffer, right?
Sorry, Craig, which plan are you on right now?
The one that your witness just threw out, or my witness, or whoever's witness is Suncrest Village. I think it's Exhibit 35.
Okay, thank you.
So you're pointing to Lot 17, which, again, is an example of a riparian buffer lot. That's what it looks like.
the plan, again, is very hard to read. It's very small. I don't see a riparian buffer on Lot 17. There may be.
Well, I'm just looking as I go into the approval, conditions of approval on page 3 says the developer proposes to disturb a designated riparian buffer, and then later on there's other references to riparian buffers, and when I look at your Lot 17 example, there's looks like water courses all over that. Where there would be riparian buffers.
There may or may not be. There's clearly no disturbance in that on that lot because it's not a developable lot, which is what you asked me about.
Well, okay. So this is an example where for around the perimeter, you might have a lot that may not have rows of vegetation planted for B1 or B2 or a fence, but where the lot is made up of a riparian buffer. Right?
Just responding to your question that every instance that we've seen has a building lot around the perimeter of the property. This is one where there is not a building lot along the perimeter of the property.
Well, let's be more specific. I'm talking about a building lot for a structure or some type of vegetative buffer. Now, normally we would be talking about B1 or B2, but you've come up with a couple examples of property that's hundreds and hundreds of feet wide where there's riparian undisturbed buffers that are in place.
I can't speak to the existence of vegetation. This isn't a landscape plan.
All right, let me show you what I mark as Exhibit 41. Exhibit 41 is City of Raleigh public records for a development known as Piedmont Point Subdivision. From 2018, it was a R6 zone property for a conservation subdivision. Is that right?
Yes.
Mr. Chairman, I'd like to introduce this exhibit into the record.
Okay.
I'm just going to briefly, I'll be like Craig, I'm not going to object every time, but I'm just going to object for relevancy because what other plans that also complied in a different way are not relevant to the plan before you today. So he can keep going. I just want to put that on the record.
So, Mr. Chairman, what I wrote down, which was in response to a direct question from Robin earlier today to Justin, he said, the interpretation that you gave to Williamson, have you used that before? And he said yes. And
I don't believe
and
any
then
of-
and then if I can finish, and then he offers up two examples, which we've talked about Barwell, and so we're going through a host of other examples where we will contend that the interpretation is different.
Okay, I contend it's not, and so that's only where I'm saying. If it's just different, so I don't believe them to be relevant, and I'll leave it at that.
What exhibit? 42. I did hand it up, right? Mr. Chairman, did I hand up exhibit 42 now that Robin?
Yeah, not to us yet.
Okay, thanks. I'd
41?
like to hand up exhibit 42 to the record.
We're in 41, I believe.
Okay, 41.
Where the heck did all the stuff go?
Oh. Yeah. So this is, for this particular development, if you turn, Justin, 1, 2, 3, 4, 5, actually several pages in, right before the administrative approval document, you'll see a discussion for this in sequence number 5, where Mr. Walters is saying, please clarify that the TCA proposed along the perimeter west of Seneca Drive meets the requirements dimensions of a B1 or B2 transitional protective yard. Do you see that?
Yes.
Okay. And then in sequence 10, as you move through this, you'll see a comment where he says lot 54 does not meet the minimum lot size for a perimeter lot. Do you see that comment?
Yes.
And then further in on sequence 4, he says the open space lot 56 shall meet the minimum width 2.2.6 and the depth of 60 feet. Do you see that?
I'm sorry, what number?
This is sequence number 4.
I see sequence number 4, yes.
So in this area, his first comment that we went over is this is an area that's shown as open space where Mr. Walters is saying you have to put in a protective buffer in this open space. Right?
I'm sorry, what sequence was that again?
Well, the first thing we went over right before the administrative action, so the first set of notes, that was sequence number 5. He's talking about the area to the west of Seneca Drive that appears to be something that would be owned by an HOA. And he's saying that it needs to meet the requirements of a B1, B2 transitional protective yard.
Correct.
So if you were right, that open space would just simply suffice, regardless of it being vegetative, why would he be making that comment?
He's making the comment because the existence of tree conservation in that area. So he was asking that the tree conservation is acting to meet both the tree conservation requirements and the transitional protective requirements, which it is allowed to do.
So in that area, in the open space, is where there's going to be a tree conservation area.
That was his comment.
Now, in his comment where it says lot 56 shall meet the minimum width and the depth, do you know what he's saying there? The open space lot number 56 shall meet the minimum width and the depth?
I'm sorry, what comment?
This is sequence number 4.
Sequence 4 says for the following comments, see sheet C1.
I'm looking at, I think I'm about 5 pages in, dated August 28th, 2018.
What page?
It is 1, 2, 3, 4, 5 pages in.
The open space lot number 56 should meet the minimum width of section 2.2.6, which is the open lot standards, I believe.
So does this, from this, can you tell if around the periphery you're dealing with a piece of property that has conservation areas as satisfying the requirements of a vegetative buffer? Can you tell from this approval?
It appears that at least on portions of the property that is the case, yes. There are, for example, to the east, I don't see any open space.
Let's go back to the conversation that you had with staff about the Williamson Drive situation. You said you were asked to give an interpretation related to compliance with section 2.3.1, right?
Right.
And so who asked you to give an interpretation?
I believe it was Daniel Stegall or a member of his team.
And when was this asked?
It would have been after April of 2022, I believe, when I returned to the office.
Well, if you look at it, I'll hand this up to you. These are exhibits 24 and 31 of the record. This is communications to you from Daniel Stegall. Exhibit 24 is from July 20th, where he's saying that Jason is under the impression that the neighborhood protective yards are not applicable to a conventional townhome development in R4 with missing middle 2.0. You see that?
Yes.
And so, do you recall that discussion with Daniel about that?
I do.
And going back through the correspondence with that's link here of emails, Jason was asking the question, can a common HOA lot, a singular lot, suffice around the periphery? He was given the answer no, and then there's discussion about whether middle housing 2 would change the standard. Isn't that what that email exchange is?
Yes, it seemed to move on to whether anything would be different after missing middle 2.0.
And so, what do you recall discussing about this topic?
I just remembered discussing it with Daniel. The question was whether, once I was brought into the conversation, was whether a conventional townhouse development in R2 would need a protective yard.
So far, you've got Keegan McDonald, Eric Hodge, looped in on emails with Jason Meadows, where the answer has been, what you're proposing will not work. And then Daniel Stiegel is not aware of a previous interpretation that would conflict with that point. And then Daniel asked you about this topic. Is that a fair recitation of what's happening?
As far as I can see, yes.
And so sometime around July to September, because the next email you see from Daniel is in, that's exhibit, was that exhibit 34 that I gave you? Or exhibit 24? What is the other email from September I just handed you? 31?
31.
So that's from September of 2021, or 2022, excuse me. He's asking you to give your opinion, right? Daniel is.
Yes.
Okay. And so are you aware before September of 2022 whether there had been any discussions about whether, with you, involving you, with whether a singular conventional HOA lot that did not have a vegetative buffer, whether that would suffice for section 3.2.1?
I'm not aware of any specific conversation, or I can't recall any specific conversation.
And I think I just inverted the numbers. I apologize. I think it's the heat. I'm glad I've got a short sleeve shirt. 2.3.1. So it's now September, and you've had apparently two. So Keegan is under you, right? You supervise him.
I do.
And he has given an answer that you can't do it. Eric Hodge is on that email exchange, and ultimately it's coming to you in September. And what do you recall then happens?
So, first of all, it appears to me that there might be two different questions. These aren't the exact same threads and the exact same conversations, but my recollection of my discussion with Daniel about Exhibit 31 was that a conventional lot that met the dimensional requirements could satisfy 2.3.1C.
Without a vegetative buffer built into that?
Without a transitional protective yard.
Or a riparian buffer, or any type of vegetation, just 4 feet of nothing and then a road, right? Because basically that's what you approved for Williams.
The approval was an open lot that met the dimensional standards for a conventional open lot in R4.
Okay. So you're presented that question in an email. Now, I will say to you, I've received 11,000 some odd documents from the City of Raleigh. Thank you, City of Raleigh. Public records. I did not see your response in writing. So when you make an interpretation, do you not normally put it in writing?
I make a lot of decisions We have a lot of discussions as staff, both with staff internally and with external folks. If someone requests an interpretation in writing, I provide it. It's not uncommon for me to discuss with my team or other members of staff provisions of the code and how they apply and how I think they should be applied. We meet frequently to discuss those things. Sometimes I provide them guidance in writing, sometimes I don't.
All right, well, so I'm not sure. So there's not a process that you, or a policy or something where you follow normal procedures that says, I'm asked to give an interpretation, I then respond in writing. You don't have anything like that. It's more free-flowing, right?
It's my responsibility and duty to be responsive to the people that I work with to give them guidance, and that guidance can take many forms. There's no internal policy or document that spells out exactly how that should be given.
Well, Jason asked in writing to Keegan and Eric for the answer. So let me ask you this. Why would Jason be asking Keegan and Eric for the answer to the question that is so important to us?
Again, it's probably during a time when I may have been out of the office. It's not uncommon for folks to reach out to Keegan and Eric. They're very capable planners. They know the code very well. They're very capable of providing guidance and answers in my absence. I may have not been available. There are a number of reasons, and I think it occurs very commonly, almost daily, where folks reach out to other members of staff other than myself on how to apply the code and what can happen.
Do you have any reason, do you have an understanding from talking with Keegan why the answer given to Jason from him was no, you can't do this?
Objection, if you know.
If you know.
I'm sorry,
Keegan gives an answer that's different than ultimately what the answer, apparently how you then later respond to this application. He says you can't do this common HOA lot. You have to do a transition protective yard buffer, vegetative buffer. That was his answer. So I'm asking you, do you know why, Keegan, did he tell you why he made that call?
Yeah, I do.
Okay. Why?
First of all, Keegan's call was that because there were no standards for townhouses in R4 under a conventional development scenario. And so Keegan wasn't pondering, it doesn't seem at that time, the option for an open lot to satisfy that standard. I know Keegan had discussions with staff members while I was out. Keegan was kind of charged with coordinating interpretations and questions while I was out of the office and getting an answer from the acting zoning administrator. So it was not uncommon for him to receive these types of questions.
Well, he was the acting zoning administrator, or there was somebody else?
No, Keegan was not. He was kind of just coordinating the intake and the response.
You said he would have talked to others. So what is your understanding of who he talked to? You said an acting zoning administrator. So who was that at this time?
Travis Crane was the acting zoning administrator while I was out on paternity leave. And again, there are frequent discussions and meetings amongst staff who apply the code.
So Travis Crane is basically stepping into your role while you're out, right?
Correct.
So Travis Crane would have your authority at the time, right?
Yes.
Yeah. So Exhibit 20 is Keegan reporting to his supervisor, because you're out, Travis Crane, where he says that a vegetative buffer is required. Right? Yes?
That a protective yard would be required.
Yep.
Under today's code.
Yeah. So he's reporting to basically the person standing in your shoes that this is the interpretation I've made, right?
Again, Keegan doesn't provide interpretations. I think this is Keegan having a discussion with Travis about his conversations to date with Jason.
Travis Crane is the one in your role providing, I guess, the authority for interpretations, and Keegan is providing what he has said to a developer applicant as to a very specific development question.
I'm sorry, the email's from Keegan to Travis.
Yeah.
Right, he's not a developer.
He's relaying that he has given the developer an answer that he has to put in a vegetative buffer.
Yes, he's recounting conversations he's had up to that time.
So Travis Crane, he's involved in, he's being alerted to this interpretation. So do you know when you came back in to the office in this time frame? Do you remember?
When I came back?
Yeah.
I believe it was at the end of April or early May.
All right. But at the end of the day, you decided that the answer to the question posed by Jason Meadows was yes. You can use a singular open lot, common HOA lot to suffice, right?
Yeah, if the lot met the dimensional standards of an open lot, that satisfied 231C, yes.
All right, so you're presented this this question. So did you go up the chain and report this to anybody, this question, this issue to any of your superiors?
I may have, but I don't recall.
Well, you may have. So who's above you?
Now, at the time this was happening, depends on what time frame.
Well, this time frame of the summer of an early fall of 2022.
Brittany Waddell was the assistant director.
Okay.
And my supervisor.
And ultimately is, well, let me ask you this. Do you recall any discussions with Brittany Waddell about this?
I know Brittany participated in our discussions frequently or commonly. I don't know if she was part of this one or not.
So you don't know? Mm-hmm. Do you recall having any discussions with the mayor?
No.
Okay. And so walk me through your deliberative process. You've said you think you looked at the correspondence between your staff and the developer applicant, Jason Meadows. You think you did review that. Walk me through your deliberative process for why you landed on the answer that you landed upon.
I had conversations with Keegan, with other members of staff about, why the answers that were given to date had been given, to understand that. And then I looked at it with my own eyes. Ultimately, I decided at the end of the day that the plain language of the code says what it says, and I'm charged with applying the code as it's written. And as the code is written, a conventional lot that meets the dimensional requirements of Article 2.2 can substitute for a transitional protective yard. I'm
glad you brought up plain language. The plain language, as we all know, and we can pull it up because you had multiple slides about it, we're talking about section 2.3.1, right?
Yes.
And it says perimeter lots.
Yes, and I think I've given significant testimony as to why that would apply to a singular.
For purposes of today's hearing, you've given your testimony about what you've done to tell these people why you think you were right. I was asking you your deliberative process at the time that apparently you made a call in the summer and fall of 2022 and asked you what you did. So you're confronted with a phrase or language that says B1 or B2 or perimeter lots. I'm assuming you know there's no B1 or B2 buffer, right?
Yes.
Okay. So then you're looking at perimeter lots. Tell me your deliberative process. You said of trying to discern that term. You said you talked to Keegan, who had already given a different answer. Who else do you remember talking to?
Daniel Stegall, probably other members of my team.
Did you talk to Jermont?
Most likely.
Did you talk to Eric Hodgej?
Most likely.
Okay. So you talked to them, and what do you know? Can you tell me what they said to you?
Jermont's role was to assist with, what was actually being proposed. I don't specifically recall what Eric's opinion or comment was.
Did you go in?
Object again for relevancy, and he's asked him the same question about 3 times, so.
Did you go and look at any previous interpretations or how it had been applied in the past at that time?
With regard to lot versus lots, that specific
With
question?
regard to the understanding of the term or phrase perimeter lots?
No. Again, it's clear to me that, and always has been, that when the code refers to lots, that refers to any lot. That was never even a question in my mind. It's never been a question in my mind for the 10 years that I've worked here, whether there had to be multiple lots or whether the provision applied to any lot. And so, no, I did not go looking for examples where there was only specifically a singular lot.
Well, I asked you at the very beginning of this journey we've been on this morning did you ever been presented with this situation of a singular HOA lot being compliant with the phrase perimeter lots? I believe you'd said you hadn't been confronted with that before. So when you make the comment, Justin, that it's always been the case, is that because you've been confronted with that issue before and you've consistently applied it, or because of something else?
I don't believe no one's asked the question, to my knowledge, because there's an obvious answer to it, in my opinion.
Yeah, so obvious answer. So you pulled up Article 12.1 about meaning of words and terms. So I'll go ahead and mark that as Exhibit.
It's already in the record. It's already an exhibit.
That's okay. I had made copies for everybody, so I just might as well use it. Here's Exhibit 42. This is from Supplement 19, Article 12.1, General Meaning of Words and Terms, right?
Yes.
I'd like to introduce this into the record. All right, did you, to answer the question that was posed to you by Daniel Stegall in September of 2022, did you refer to Article 12.1 at all? Do you recall?
I likely did. It's
Okay,
common
likely
for me
did.
too.
All right, so let's start with all words in, this is subsection A. All words and terms used have their commonly accepted and ordinary meaning, unless they're specifically defined in this UDO. You see that?
Yes.
Is the term perimeter lots, is that defined in the UDO?
No.
So commonly accepted and ordinary meaning, let's just take the word lots. Common, ordinary accepted meaning of the word lots. It's more than one lot, right?
Without context, yes.
Okay. And then it goes through the hierarchy. If there are other court decisions or Board of Adjustments decisions specifically interpreting this, which there's not, right? That you're aware of?
Not that I'm aware of.
So then it says you consult definitions in a legal dictionary or ordinary dictionary. Did you do that?
No.
If you go to an ordinary dictionary for the term lots, it's plural for more than one lot. Would you agree with that?
Yes.
And then statement of purpose of intent of the UDO. That's the next thing. I think you agreed earlier that the whole point of transition protective yards is to preserve neighborhood character. Then you went on to expound upon that to say, well, it does provide acoustic and aesthetic buffers. So, so the interpretation you gave where this road going into this development is basically 4 to 5 feet from the perimeter property line. How's that serving that purpose?
I never get to this section. I don't consider intent when the language of the code is not ambiguous.
Yeah, not ambiguous. The word lots are not ambiguous.
Well,
Perimeter
how
lots.
would the multiple lots would not affect the setback of a driveway in any way, shape, or form? So it's there's no need to consider that.
Well, when we've gone through a lot of the other examples of compact or conventional developments, and let's just take this one, which was part of the record, Brindley Manor. Brindley Manor. You've got more intense development occurring in the interior of the development, smaller lots. Then you have around the perimeter, you have conventional lots for structures, right?
Yes.
Yeah, so that's not what you approved for Williamson, right?
It was a different plan. They both complied with the code.
Well, I'm just trying to figure out, again, I do think perimeter lots is a plain term that requires multiple. But let's move on. I think you said in testimony that today you can point to a state statute about where it says in a rule of construction in a state statute, rule of construction is that a singular can be plural and vice versa. Remember testifying about that?
Yes.
Did you actually refer to the state statute when you made this decision?
No, I don't think I did.
Is this something did you find this in preparation of this hearing, this state statute?
That was as part of discussions with my attorney.
All right. Well, we don't need to go any further. But at the end of the day, this state statute, you now are telling the board, justifies the interpretation you gave. It wasn't part of what you looked at when you made the decision. And in fact, it's something that your attorney found for purposes of propping up your decision for today's purposes, right?
Objection as to any discussion between us, please.
He's already done that. So I'm just simply saying you just basically relied on your lawyer to give you this to prop up what your interpretation
Objection.
is. I'll move on. So that state statute, we can pull it up, it dealt with rules of construction, right?
Yes.
In Article 12.1, the City of Raleigh has not adopted rules of construction set by the General Assembly in Raleigh. It doesn't refer to rules of construction established by state statute, right? It doesn't say that.
Objection. This has to do with the legal interpretation of the rules of construction, so he can answer, but I think that my brief that I handed up will cover this very thoroughly, but you can continue the questions. It's all answered in our supplemental brief.
Yeah, so to get to the nuts and bolts, your attorney in her brief refers to the fact there's a state statute that sets a rule of construction dealing with plural that the City of Raleigh has not adopted, but you're pointing in your testimony to Article 12.1B4, where definitions of similar terms contained in federal and state statutes and regulations. You remember that? That's what you pointed to.
I don't remember pointing to that specific section.
I'm going to object again. The brief clearly says that boards of adjustment and planners use states' rules of construction to construe municipal zoning ordinances. That is the law of the state. He can beat up on him for as long as he wants, but the law of this state is that the rules of construction for state statutes is applied to municipal ordinances, which is what this board will be called on to do. But he can keep on. I just don't know where we're going to keep on with Justin in this manner.
I'm just simply, Mr. Chairman, I'm just walking through what the city of Raleigh has put as standards for when faced with a term and interpretation, and it doesn't incorporate rules of construction of state or federal law. It says if there's a definition of a similar term. And are you aware of the term perimeter lots being defined in state statute or federal statutes?
No.
And then ultimately, you have a Article 1.1 of the UDO that says says conflicts and duplications among portions of the UDO shall be resolved in favor of the more stringent regulation. Does that sound right?
It does.
Mr. Chairman, can I get a forecast of when you wanted to break for lunch?
I think we'd all like to break very soon. I wasn't sure how much longer you were going to be taking with this witness, so I wanted to.
Maybe 20 minutes, but
Would it disrupt your rhythm, if I may put it that way, if we took a break now?
it's fine.
Thank you. Let's, if it's no objection from anyone else, let's take a lunch break, and let's try to keep it to 45 minutes if we can. Is that reasonable? Let's come back here, 1:20.
Yeah, Mr. Chair, that sounds reasonable to us. I would just like to note, we're approaching 2 hours of cross-examination where we took a little over an hour of direct, and that this is a pattern that I think y'all have experienced for 4 days. It's great to hear that Mr. Justice thinks he only needs 20 more minutes, but we just, we took heed to your comment at the beginning of today's session to keep things moving, and we're looking forward to keep things moving.
Okay, noted. Thank you. back to you.
Two things, housekeeping, Mr. Chairman. One, can we get a sense of today's schedule? I have John Solic here, who wanted to testify. He has surgeries on Mondays, and so his testimony should be 10 minutes. And so if we go past today, I'm just wondering if we could fit him in, because I think that the backup date was Monday.
Monday, yes, sir, right after our board meeting Monday morning.
Yeah.
So probably 10:30, 11.
Yeah. So it would be lovely if we could just fit him in for 10 minutes at some point after we get done with, at some good breaking point.
So, Ms. Tatum, we're going to have the continuation with Mr. Romea, and then you have, how much more? You and Mr. Birch?
I can use this one if you want. Well, I mean, you go ahead. Where's Travis?
Yeah, so I believe we have just a few minutes of redirect for Mr. Romea. I believe Ms. Tatum has one additional witness. I appreciate Craig raising this issue. We were going to ask the board to help us map out a timeline as well. We are willing, we really would love to have a decision today. Understand that may be Monday. We are willing to do what it takes in terms of limiting our witnesses, cutting our witnesses to make that happen. It sounds like the city has one more witness. Again, we may not put on any witness in the interest of time, which would leave Mr. Justice's rebuttal.
Okay.
So it'd be good to have a sense from him. He subpoenaed 3 witnesses, now has a 4th.
Okay. Good point. Thank you. So I don't know if we turn it to you 2:15, 2:30, I don't know that we will. Do you think you be able to wrap between then and 5? I don't want to push you, just you have a sense?
Well, I certainly would be able to finish Mr. Solic fairly quickly, or Dr. Solic fairly quickly. The other 3, I think I projected an hour and a half, 90 minutes, and what I, as part of the subpoena. So
90 minutes combined?
Correct.
Yeah, okay. Okay, well, I'd love to plow ahead, and if we can finish today, it'd be great for all of us. We won't know till we know.
Yeah.
And as we get further, once we get to you, in the interest of your witness's time and conditional, you can jump right with him if that suits you.
Yeah, that's great.
And that way he won't have to come back Monday if Monday is necessary.
That's great. And the second other thing is minor. The studio audience, people from the public looking in on this, may not know that we don't have air conditioning.
Right.
And that's reason I got shorts. I knew we weren't going to have it. Got a short sleeve short, a little more informal. Anyway, there was apparently a comment about apparel. So anyway, for those in the studio audience watching this.
Well, I'm glad you pointed that out. I guess we are taken for granted, but there are people watching. And yeah, it's warm in here and getting warmer. The air conditioner has been broken and it's slowly being fixed, but very little evidence of it in this room. So that's why we'll all be moving right along. And if we have to finish early because it gets too hot, that's also an option.
One other thing, I think Mr. Birch and I are willing to not only not call witnesses we'd otherwise call, but commit to time certain for witnesses. I mean, I'm glad to commit to, I won't go over 30 minutes or 15 minutes or something. If that could help, it's getting to the point where not finishing will be a loss to even if we win, so because of the time constraints.
Well, I think there's also something to be said for repeating information that's been already presented. I understand the necessity sometimes to reaffirm points, but there's a certain amount of that's taking place. And out of respect for all of us, and knowing this is going to go forward to probably an appeal situation, I understand the need to get these things in the record. But at the same time, if you know you're reaffirming points that have been made, we'd appreciate if you just state that and then move on, if that's possible. So Mr. Justice, it's now back to you and Mr. Romea. Anything else, Mr. Birch? Okay.
Justin, let me show you what I mark as Exhibit 43.
Well, it's the camera.
This is a Exhibit 43 is a set of City of Raleigh public records dealing with a development called Watkins Subdivision. Is that right?
Yes.
And this is a compact subdivision development from 2021. Is that right?
Yes.
Mr. Chairman, I'd like to introduce this exhibit into the record.
This is number 43.
Yes, sir. Yes, sir.
Okay.
So if you would, Jason, this is, Justin, I'm sorry. This is at a time where you're zoning administrator, right? You've officially ascended to that role, correct?
Yes.
All right. If you will look looking at the staff notes. And I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 pages in with a topic called protective yard at the bottom. Do you see the two comments down there about protective yards, both in the section where it says protective yard, and then in the Lot 101 designation, there's a question about transition yard buffers. You see that?
Yes.
And then, and as you look at those notes and then turn 2 more pages, there's a discussion about the transition protective yard site boundary at the bottom of that page. Do you see that?
Yes.
Now, on page, let's see, page 6 of this, there's a comment where it says there appears to be long stretches of site boundary where no transitional yard is provided. For example, on open lot 103. I'm going to find that. That's on page 6. If you get to that comment before me. Do you see it?
No, I don't.
All right, it is. Sorry. I may have to come back to it because I just had the thing on in front of me. Well, there appears to be, through those comments I gave you, there appeared to be a discussion about whether or not an open lot needed to have a transition buffer yard. And the example that was given is open lot 103. Do you see where open lot 103 is on the set of plans?
I don't. Can you point me to it?
Yeah, hold on one second. Yeah, I think I grabbed the wrong set of plans. I'll tell you what, I think I may have grabbed the wrong set of plans, so let's just move away from that right now, because I cannot see where that is. This is overlook at Harris Creek is what I'm looking at my notes. And this doesn't appear to be overlook at Harris Creek. Yeah, so let me come back to it. I apologize, Justin. Let me show you what have already been introduced as Exhibits 27, 28, and 33. So Exhibit 27, 28 is for the development of Barwell. And you see the communication at that time. This is in the summer of 2022, where you're tackling the issue of Williamson. And at that time, the city staffer is indicating to the developer that what is being proposed, which is an HOA lot that doesn't have a transition protective yard, an HOA common lot around the perimeter, is not going to work. And that's a copy of the plans. It's included in the exhibit that's already made part of the record. Do you see this common HOA lot around the periphery right here?
I do.
And so the comment from the city staffer at that time is that this is not going to work because it needs a vegetative buffer. Do you see that?
This is a discussion between Jermont and his supervisor and me. I don't see any correspondence with the developer.
It's in the, if you look in, I've given you a copy of the comments, staff comments.
Oh, you're on 28 now?
Yeah. And the staff comments is, if you turn what's highlighted at the very back of that, he's saying that a transition protective yard is required and that the HOA lot will not suffice. And that's what he's saying?
It's a large paragraph. Can I have a minute to read it?
Sure.
Appears to me that the comment says staff will inform you of a decision for this next week.
Well, he's indicating there's a problem with it and that staff will inform of a decision. And ultimately, you have the correspondence there. So do you recall this Barnwell situation coming up where the developer is, they're telling the developer, it looks like we've got a problem, we're going to have to deal with it. So did you deal with this particular issue as well?
Clearly, I was emailed about it.
Well, what do you recall discussing about this particular development?
Well, again, this is a question about how the missing middle 2 ordinance is applied, just as the other ones were, but I think where we landed at the time was that the perimeter lot could comply so long as it met the conventional lot dimensions.
You just said middle housing 2. Did you mean middle housing 1?
No?
So, like this, because you almost said like the Williamson, you were applying middle housing 2 ordinance.
No.
You're not applying middle housing 2 ordinance to Williamson, right?
No.
And so so again, are you applying middle housing 2 in your what you were reviewing there for Barwell?
All I know is that the question seemed to revolve around a 2-unit townhouse standard, which was part of the missing middle 2 ordinance.
All right. So you don't recall any discussion specifically about Barwell?
I do recall discussing it.
Okay. So who did you talk to?
Daniel,
And
Jermont, probably other staff members as well.
okay, is it around this time frame of August of 2022?
Yes.
And what do you specifically recall?
I recall deciding that a conventional lot could take the place of a transitional protective yard.
And did you communicate that to the developer?
Not to my knowledge.
And why not?
I typically don't communicate to the developer unless they ask me. I don't preemptively reach out to developers with decisions.
Gotcha. All right. So earlier you were asked from council about the various stages of development approval, and that this compact development approval is one stage of others. It's just one stage of many development approvals that will have to occur relating to the Williamson project, right?
I did.
And in terms of the development approval that was signed off by Daniel Stiegel in December, does that create any final determination of a zoning determination or interpretation, in your opinion?
What it does is approves the plans, which are the first step in the process.
Okay.
Yeah.
So as part of that, there was a final determination that this project and application qualified as a compact subdivision, yes?
Yes.
There was a final decision and determination that a vegetative buffer was not required along the periphery or perimeter.
Do you mean a transitional protective yard?
Yes.
Correct.
There was a final determination that a one singular HOA lot of varying dimensions would suffice around the perimeter for purposes of sections 2.3.1, yes?
Yes.
There was a final determination as to the designation of what the primary street was, yes?
Yes.
And the primary street establishes setbacks for what's the front, side, and rear, right?
For lots that front on the street.
Yeah. Is that right?
For lots that front on the street, not for lots that do not front on it.
Okay, for lots that front on the street. So we just rattled off at least 4 different determinations that were final determinations that if my client had not appealed within 30 days of Daniel signing off, those would be decisions that would be binding on everybody, right?
I think decisions are made every day when plans are approved.
I'm just trying to understand is the determination of it qualified as a compact development, there's no transition protective yard required, a singular open lot, HOA lot is sufficient in the primary street designation. Those are all determinations that got wrapped up into what Mr. Stiegel signed off on in December.
What
Yes.
Mr. Stegall signed off on was an approval of the subdivision plan. Not all of those decisions that you just rattled off were novel. There was nothing novel about those interpretations.
The question
every
is, are they final?
every plan with more than one street, a primary street designation gets made, and a decision has to be made. Of course, those decisions are appealable.
Would you agree that the effect of my client not appealing within 30 days is that the decision that this qualified as a compact development would have been made, and they would not be able to challenge it if they didn't appeal it within 30 days?
Yes, that's how it works.
Yeah. So, right. So there were very important decisions that were made and ultimately wrapped into this development approval at this stage.
Can I object? He's asking him legal questions that are really for a court to decide at some point in time in this board, so it's not anything within his factual knowledge.
That is a little bit, Mr. Chairman, respectfully, confusing because he was asked questions about different development stages to give some picture that, oh, there's no injury because there's no really decision that's made that's going to turn dirt. When we really, all of us in this room should move beyond that and not waste our time and point out there were very important decisions made with that development approval.
It's a lot more complicated than that, and I could argue the other side all day. I want to make it clear that whatever Mr. Romea says as a zoning administrator about the effect of any decision or any appeal is not something that's binding, so I am objecting to that. And I do not think we're wasting time. I think that the thing on appeal is a subdivision plat and no more. There are decisions in it. There are a component of that plat. Now, when the next decision comes along, there may be another decision that is encompassed with this, that things may have changed. We don't know that. Right now, what's in front of you is a plat with decisions in it. Now, what the effect of that is, we can argue later, but it is not Mr. Romea's call ultimately about what the injury is or what the effect of any particular decision is. So that's all I'm saying for the record.
It's a somewhat disingenuous position to suggest that the development approval, it wasn't important enough with decisions being made that it started a time frame for appealing. I will move on, but the picture that they want to paint to you is that somehow nothing final has been decided. In fact, a compact subdivision development has been approved with this approval, right?
Yes.
And let me interject, it's a final decision, that's why we are here. As far as injury for purposes of standing, that's a legal question for later, and you can keep asking him again. I just want my objection for the record because I don't want anything binding that he admitted anything without my objection. So with that, we can move on because we're well past 20 minutes.
Mr. Chairman, this is the reason why I can't give a time frame, because they keep talking, and so I never can predict. Exhibit 44. Let me show you what I mark as Exhibit 44. Exhibit 44 is a communication between you, well, that involves you, Justin, right? Is it email communication?
Yes.
And it's about the table that's in Article 1.3.2, is that right?
That's what's listed in the email, yes.
Mr. Chairman, I'd like to offer up this exhibit in the record.
Okay, it's 44.
Yes, sir. You mark it for me. Thanks. So there is a question here about a footnote where it makes, well, the email suggests that there appears to be an issue about whether the reference in the footnote to the TOD overlay affects whether or not townhouses are permitted in R6. Do you see that?
Yes.
And that's the issue we've raised about the footnote that's in this table, section 1.4.2, where for R4 townhouses, there's a footnote 1 that says in R4 and R6, townhouses and apartments are allowed as part of an improved development in the TOD overlay, right? It's the same issue. Yes?
Yes.
And so you're, in this email, you're identifying that as a problem, right? You're agreeing it's a problem that needs to be cleaned up. Yeah?
I stated that we were planning to clean it up, yes.
Yeah. So the thing about cleaning up is it's part of the ordinance, is it not? That footnote.
It is.
And your ordinance does say that you apply the most restrictive provision that's in an ordinance, right?
It does say that.
And at the end of the day, if you wanted to clean it up, you certainly could remove that footnote, but for purposes of this Williamson application, that footnote was in place at the time of the application, right?
I believe it was.
Now, you, to address the meaning of perimeter lots, your attorney was asking you questions here in front of the board about the fact that the UDO contains many, uses the plural multiple times throughout the ordinance, right?
Yes.
So you would agree that there is more than one lot in the city of Raleigh, right?
Yes.
There are, how many, there are thousands and thousands and thousands of lots in the city of Raleigh?
Probably.
Yeah. So at the end of the day, it's not surprising that you will find in some sections the use of the word plural when at the end of the day we all recognize there's a lot of lots that already exist in the city of Raleigh that are being regulated every day, right?
Right, and they're being regulated individually.
Individually, yes,
Yes.
but as a whole, they're being regulated as well, right?
Sure.
Yeah. So, but for purposes of the perimeter lots, that applies to a very specific regulation where someone is asking for a specific approval for a compact development or a conservation development, right?
Yes.
And at the end of the day, you believe that for the periphery or around the perimeter of the Williamson project, that having one HOA lot suffices for the term perimeter lots, right?
I believe that one lot that meets the dimensional requirements of Article 2.2 meets the requirement.
Now, and it's because in part, it's because your interpretation is that this area that's above the TCAs, and I say above, meaning running north from this TCA and that TCA around the periphery or the perimeter, that is part of an open lot, right?
Yes.
Yeah, because everything that you see in color here has been connected by the way they've drawn this map as one lot, right?
Correct.
So in terms of what an open lot is, you understand there are different standards for lots depending on whether you intend to use it for a detached house. There are different standards for that than when you have a attached house or a townhome, right? There are different standards.
Yes.
So when you analyze what standards to apply, you ultimately have to see what is being proposed as the use of the property, right?
Certain standards, yes. Certain standards, no.
Well, you made a big deal saying that attached lot standards are different than townhome standards. So you have to look and see, am I proposing to use the property for a townhome versus an attached
Objection,
unit?
those are building types, not uses.
If you don't understand my question, please tell me.
I understand your question. Our code, as Robin said, is a form-based code that has requirements that pertain to the buildings, regardless of their use, and then there are requirements that apply to the uses themselves. So if you want me to comment or respond to something, you have to be more specific.
All right. So for a detached home lot, you would look at the type of building being detached and the fact it would generally be occupied for residential purposes, right?
Generally, but not always, yes.
Well, let's jump ahead to open lot. It's a defined term, right?
It's a defined building type, yes.
Well, it didn't you said earlier it didn't have to be a building.
Open lot is one of the allowable building types.
Okay, so in the definition of open lot, do you know what the definition is?
I can't recant it from memory, but it's a lot that generally accommodates open spaces. Building size is limited, but is not prohibited.
The definition is in Article 1.4, right?
Yes.
So I'll hand you what's already been entered in the record as Appellate Exhibit 4, which is the 19th supplement. So if you would find the definition of open lot for me. Go ahead and read it.
Open lots are used to accommodate uses with large outdoor or open areas. An open lot can also accommodate open space, parks, or natural areas.
So open lots are used to accommodate uses with large outdoor or open areas?
That's
Or
what it's-
large outdoor areas?
Large outdoor or open areas.
Okay. And so then it says an open lot can also accommodate open space, parks, or natural areas, right?
Right.
So let's just look at that second part of that. The area that's north of these TCAs, as it works around the perimeter, that area is not, y'all admit, it's not open space. It doesn't qualify as open space, right?
It was not included as a required open space. I've
Yeah,
done
because-
any evaluation of it, but yeah, it
Well,
wasn't
it's-
counted as open space.
It's not counted as open space because it doesn't meet the criteria for open space, because you have specific criteria that says it's tertiary or secondary or primary, and this space around the perimeter doesn't qualify as any of the classifications you have for open space, right?
It may or may not. Just because it wasn't counted as open space, once the applicant satisfies the requirement, they don't need to provide additional.
What number am I? All right. Let me show you what I'll mark as Exhibit 45. Exhibit 45 is from Supplement 19, Article 2.5, dealing with open space requirements, right?
Right.
Mr. Chairman, I'd like to introduce this in the record.
Okay.
And again, for purposes of this line of questioning, because I was just trying to get you to say that this space, this area around above the TCAs are not open space, and you wouldn't go there. So I'm talking about the area north of these TCAs around the perimeter. You with me?
Yes.
So which of the classifications for open space would you say that area qualifies for?
I don't know that it does or does not. All I was saying simply was that I did no evaluation of those areas and whether they qualified as open space. The amount of required open space was satisfied on the plan, and there is no obligation to exceed that amount. So once you get to the required amount, you can stop whether additional areas that qualify exist on the site or not.
So we were just getting into the definition of open lot, and an open lot in the second sentence says an open lot can also accommodate open space, parks, or natural areas. So let's start with parks or natural areas. You would agree that what is consisting of the area outside the TCA along the perimeter is not a park or a natural area, right?
No.
Now, in terms of open space, does it meet the criteria for open space?
I don't know.
Well, look, so primary open space, is it one of those things? It's not a transitional protective yard. Does it meet any of the primary open space?
If you want to put that slide up, it's number 26. That might be helpful.
Is it primary open space? Does it meet one of those categories?
I don't know. I'd have to read every category and examine the plans.
Okay. You're saying that along the perimeter, there is an open lot. An open lot has a definition. So I'm trying to understand, we know that it's singular, not plural. I'm just trying to understand whether it met the qualifications for being part of an open lot around the perimeter.
An open lot need not contain open space. An open space need not be contained on an open lot. They're two separate and distinct terms.
So the open lot definition, so can you or can you not, as you sit here today, tell me whether the space around the perimeter for the Williamson project would qualify as open space? If you can't, then I'll move on.
Certainly some of it does and has been dedicated that way.
The TCA, Justin, is certainly the case. The space above the TCAs around the perimeter, basically, you would agree that the road can't be open space.
I do.
It's a prohibited use.
Yes.
So between the road and the perimeter boundary, what would qualify as open space, be it primary, secondary, or tertiary?
It depends on what exists. This is a plan. It doesn't show existing conditions. I don't know what is in that area. I don't know if there is vegetation, if there is floodplain. I don't know if there are steep slopes. I don't know if there are other areas that qualify as open space. Again, because it was not evaluated, because it was not necessary for the approval of this plan.
So the answer is you don't know, right? Isn't that fair to say? You just don't know.
Yeah, I would have to
All right.
review the plans.
So the open space, the dimensional standard is that the open space has to be at minimum width of 50 feet. You would agree that you can't count the road because the road is not open space. It's a prohibited use. So is there a minimum width around the perimeter?
A minimum width of what?
Of the space. With Daniel's testimony, I called it garbage space, but the space that's between the road and the perimeter boundary, is that a width of 50 feet?
Portion of it's not dimensioned. Certainly not throughout its entirety. It's not, but portions maybe.
Okay, so portions would not. And you would admit that in terms of prohibited uses, the street and parking area cannot constitute allowable open space. and that's section 2.5.6 of the code, right?
Yes.
So for purposes of 2.5.4, which is allowed uses of open space, would you say any of that small width of space, would that meet any of the allowable uses?
Again, it certainly could. I don't have enough information to tell you that.
Which one could it?
It could be a conservation area for natural, archaeological, or historical resources. There could be meadows, woodlands, wetlands, wildlife corridors. There could be trails. There could be passive recreation areas proposed there. There could be active recreation areas proposed there. There could be water bodies on the
I
site.
just want to make sure that everybody understands what he's saying, is that this space around the perimeter here, that could be trails and recreation and...
Objection, he has testified already, and we've asked the same question numerous times, and I think we agreed we wouldn't do that. So, again,
So in terms of the first part of the definition, open lots are used to accommodate uses with large outdoor or open areas. Are you telling me that knowing that the parking and the street can't be open use or open space, this space around here, is that a large open or outdoor area?
Appears to be large. Appears to be nothing proposed to be built on it.
It's large in the sense of being
The-
basically the width of this aisle right here?
Well, in one dimension, it's several hundred feet long.
Yeah, one dimension. So this is a large open space.
No, that's a large open space.
Okay. That's all the questions I have, Mr. Chairman.
Thank you, Mr. Justice. Board members, do you have any questions for Mr. Romea? Did we get first shot? Okay, seeing none from the board, we'll go back for a redirect if you have.
I'll try to be brief. Just quickly, if we could put slide 13 back up on the screen, please. Okay, you testified earlier that this is what is known as an administrative subdivision approval. Is that correct?
Yes.
And that means that the objective, non-discretionary standards must be applied by the staff.
Yes.
Okay. Does the staff have any authority to change the wording of the ordinance or add requirements that are not there?
No, they do not.
Okay, is that the whole point of an administrative subdivision decision?
Yes.
And review as to whether those standards are met come to this board, which is where we are today.
Correct.
Okay, again, I'm trying not to be repetitive, but just to go through a few things. The requirements here of 2.3.1C that we are concentrating now on the perimeter lot option, correct?
Correct.
And there is one requirement and one only for that perimeter lot, is that correct?
Yes.
And
that's
so we
correct.
go to section 2.2. And if you'll go to the next page, 14, that's the open lot standard, and that's what you testified applied, is that correct?
Yes, it is.
Okay. And with dimensional standards, there's no building, as you said. So under R6, those requirements are area and width. Is that correct?
Yes, in all zoning districts.
Okay. There is no requirement for planting there, is it?
No, there's not.
Would you be allowed to add a planting requirement for that?
Yes, you could.
Could you
Not a
re-
requirement.
could
Staff
you
could not add a
require it?
requirement.
Could you require
No.
anything other than these two things?
No, staff could not require that.
Okay. So on these number of plans that Mr. Justice has shown you, do they all meet these these requirements of 2.3.1 and 2.2?
Yes, in my opinion, they did.
Okay, but they meet them, they have a different lot configuration, is that correct?
Correct.
Some may have open lots, some may have protective yards, but all of them meet them in whatever way that particular plan meets them, right?
Right.
So the fact that other plans were approved under the same provision does not mean Williamson cannot be approved. Is that correct?
That's correct.
It is evaluated on its own merits and its own width and its own dimension. Is that correct?
Yes, it is.
Okay. Is that influenced in any way by plan comments between staff members on other plans?
No, it's not.
Do emails between staff members change the fact that you have got to apply this standard and this standard only when you review a subdivision?
No, they do not.
Okay. You testified you're the zoning administrator,
I did.
and you're the final say on zoning determinations.
Correct.
Even though you have superiors, that people that you report to, do they have the authority to overrule your zoning determinations?
They do not.
Okay, that's final with you regardless.
It is.
Okay. If you can turn to that open lot slide one more time, which is in the, I think it's the very last one, 26. Okay, and as you were reading there, it says, it's basically telling you what an open lot is, and it says it's used to accommodate uses with large outdoor or open areas. Is that correct?
It is.
And then it says it can contain open space. Is it required to contain open space?
No, it is not.
Is it required to have a park
No, it is not.
or a natural area?
No, it is not.
Okay, so in your opinion, it is an open area, is that correct?
Yeah, in my opinion, the open lot 18 does contain some of these things. It does contain open space. The entirety of the lot, or the fact that portions of the lot may or may not qualify or may not have been counted as open space, does not disallow the use of the lot as a whole to be an open lot.
Because that's covered by the first sentence, is that right?
Correct.
Okay. Give me 1 second, I think I'm done. Okay, and with the other plans, just because an open lot or a perimeter lot has plantings on it, doesn't mean they're required. It's just, it can, it may, and it may not. Is that correct?
Yes, that's true. Yeah.
Mr. Birch?
Mr. Chair, just wanted to touch base with Justin on, I'm not going to go through every plan that was provided to you by Mr. Justice, but want to ask you questions about we'll limit it to 2 of the plans. So let me start first with what was Appellants Exhibit 41, which is the Piedmont Point subdivision. And recall, this is a conservation subdivision for a property that was zoned R6. And so I'll just direct your attention to the first page of the subdivision plan itself, the folded out map. And we'll direct your attention to the southernmost end. You'll see open space lot 57. You see that?
Yes, I do.
And do you see lots 32, 33, 34, 35?
Yes.
And note that those are all under the conventional standard of 6,000 square feet for detached homes.
That's correct.
They're less than that. They're all around 4,000 square feet.
Yeah.
And there's no transitional protective yard on the edge of those lots, are there?
There's not.
But there is an open space lot between the rear of those lots and the adjoining property. That's the open space lot 57.
That's correct.
Okay. And is there a stormwater pond on that lot?
Yes, there is.
Okay. There's no tree conservation between those lots, call them 32, 33, 34, 35, and the adjoining properties on the other side of that open space lot?
No, there is not.
Okay. And there's no type B1 or B2 on that open space lot, is there?
No, there's not.
Okay. So I want to also direct your attention to what is Appellants Exhibit 39, which is the Barwell Park subdivision. This is the one that you reviewed as a coordinating planner. Is that correct?
Yes.
So again, I'll direct your attention to the first page of the subdivision plan. It folds out. The front of that document has the kind of case cover page. It says Barwell Park subdivision.
Apologies, there are a lot of exhibits here. Okay, 39, I have it.
You got that? Okay. Yeah, so when you fold out that subdivision plan there, again, this is a compact subdivision, split zoned R4 and R6. I think I'm directing you to the portion of the project that is zoned R6. If you can find lots 11 and 12, which are kind of on the southern end, call it southeastern end. Do you see those lots there?
Yes, I do.
And those lots look to be about 5,000 square feet, a little over 5,000 square feet.
Correct.
And so that is less than the conventional lot dimension for a detached home in R6.
Yes, it is.
And there's no transitional protective yard, B1 or B2, on the rear of those lots?
No, there's not.
Okay. Direct your attention to lot 108. Appears to be an open lot that it has frontage on Musket Court, but then it comes down and goes around and is behind lots 11 and 12. Is that correct?
Yes, that's correct.
And so between there, particularly immediately behind lots 11 and 12, that appears to be a private drainage easement for a stormwater pond. Is that right?
Yes.
There is some secondary tree conservation there, but that's a little to the east. But there's no type B1 or B2 buffer where there is no TCA. Is that correct?
No, there is not.
So it appears in both of these cases that an open lot served for compliance for that subsection C1. You know, it's a perimeter lot, correct? It's not a type 1, a B1 or B2. Is that correct?
That's correct.
Great. And that is similar to the case with 908 Williamson, correct?
It is, yes.
All right. That's all the questions I have.
Thank you, Mr. Birch. Justice.
Yes. Justin, since you have Barwell open, which is exhibit, exhibit 39. The area you're talking about, lots 11 and 12, immediately to the south of that area is an area denoted as secondary tree conservation area.
No, it's not.
It's providing a width. When you say no, it's not, where does it begin and end?
The tree conservation area is denoted by the dashed line. It's a rectangle. It's approximately 247 feet long, 65 feet deep on the western end, and 89 feet deep on the eastern end, and it ends at the southeast corner of Lot 12.
Can you tell me what's in that triangular area? Really, as you sit here today, since you couldn't even tell me what's going on with the Williamson project, can you tell me exactly what's going on then immediately south of lots 11 and 12 on this plan?
Other than what the topography tells me, I can only tell you what it does not contain.
Do you know if it contains vegetation?
I know that the stormwater drainage easement would not contain vegetation because it wouldn't be permitted.
Where's the stormwater drainage easement?
It encompasses the dry pond one. It also appears to be some sort of easement that runs along the rear of lots 11, 12, and 13.
So is the dry pond easement, to the east of that is the riparian buffer for the Neuse River, right?
To the east of the pond, yes.
Yeah.
Yeah.
And again, I'm asking you that in this area immediately south of lots 11 and 12, can you honestly tell me today whether or not that area contains vegetation or not?
No, I can't.
And then going to Exhibit 41, if you start from the back and you go 2 sheets from the back in terms of the plans, what is west of Seneca Drive between the lots 44 and to 36, there's a secondary tree conservation area right there, right?
What plan is 41?
That's Piedmont that Mr. Birch was asking you questions about.
Okay, repeat the question.
Well, west of Seneca, in this open area that's presumably be conveyed to an HOA, between the perimeter lot boundary and lots 44 through 36, that's a secondary tree conservation area, right?
Correct.
And then just immediately south of that, well, lot 57 is inclusive of that secondary tree conservation area, right?
Yes.
And then immediately south of that is a stormwater drainage or a stormwater pond. Is that right?
There's a stormwater pond on on lot 57.
And there's vegetation that's required around that, right?
Around the pond?
Yeah.
Yeah, there's screening requirements.
Yeah. So if you turn to the very last sheet, so south of the secondary tree conservation area is this pond, and around the pond is required landscape vegetation, right?
There are shrubs shown around the pond, yes.
Mr. Chairman, on my notes, I see Exhibit 43, and that was the plan where I think there was a different Watkins development that I pulled out of the folder rather than the Watkins Glen. I just want him to substitute 43 because we didn't really get into that or hand it up to the board, and so it's just this odd exhibit. So if I could substitute the right exhibit.
Any objection? Go ahead.
What, you gave us the wrong one? Is that what happened?
I handed up the wrong one. You have Exhibit 43.
It's in here somewhere.
So are you wanting to label this as 43 or 43A?
43. This is 43.
Okay, so the 43 that's in the record now, what do we do with that one?
I think you should name it 43A.
All right.
Keep that one in the record just to
43A.
Thank
get
you.
up,
Thank you.
authenticate whatever it was.
Let's go ahead and mark it 43A. This 43A is for development called Overlook at Harris Creek, AKA Watkins Glen, right?
Yes.
Mark on this. I'd like to hand up Exhibit 43A.
Okay.
So you accepted 43A in the record, did you not, Mr. Chairman?
Yes, sir.
Okay. Now, this is for a conservation. Yeah, this is for a, one second. Conservation subdivision, right?
Yes.
Yep. For R4 property, right?
Yes.
So the comment I was trying to get you to look at, but I had the wrong staff note, 43. If you go 1, 2, 3, 4 pages in, you'll see comments that corrective action that says please demonstrate compliance. This is January 9th, 2020. Do you see sheet C11 comment that says there appear to be long stretches of site boundary where no transitional yard is provided? For example, on open lot 103, please explain. Do you see that?
I do.
And if you turn to the plans that were approved, there are, within the open lots that would be conveyed to an HOA, there's a substantial vegetative buffer that's being provided, and where it's not being provided, there is this comment to explain why, right?
That's what the comment says, yes.
And so just, isn't it a fair reading of this comment to say that simply having an open lot is not sufficient for purposes of satisfying the either the perimeter lots standard or the vegetative buffer standard, at least in this instance for this development?
I think, as I've said many times today, I don't think that's correct as the zoning administrator. I don't know what an individual plan reviewer was thinking when they wrote the comment or had in mind when they wrote the comment.
But that's what appears to be the issue, is non-compliance with an open lot needing to have a transition buffer as part of the open lot around the perimeter. That's at least what this issue looks to be, right?
Yeah, I mean, that's what we can read, that's what the comment says.
So I think your attorney asked you that, well, what you did for Williamson is really specific to Williamson. And Justin, you would agree that when you try to interpret something like what does perimeter lots mean, and how do you satisfy section 2.3.1, how the city may have approached it in the past would be relevant, right?
It could be relevant, sure.
Could be relevant, meaning if you had a number of developments being approved dealing with the topic of either a transition vegetative buffer or conventional perimeter lots, you say it could be important. Why wouldn't it be important to see how these provisions have been applied in the past?
It would be important to see how they were applied in the past. If they were applied incorrectly, that's not a reason to. I'm not saying these were, but that would be a reason to not continue down the same path.
Okay. And my last question to you is, for purposes of making the decision on Williamson, you did not go through an examination of other conservation developments or other compact developments to see how the standard in question, dealing with transition protective yards or perimeter lots, how that had been applied when you made your determination, right?
I don't remember doing any specific digging into that issue.
That's all the questions I have, Mr. Chairman.
Okay, thank you. Mr. Mehta, thank you very much. Appreciate your time. Ms. Tatum, you want to call another witness?
One more quickly.
Thank you.
Travis Crane.
Mr. Crane, do you swear or affirm the testimony you will provide will be the truth, whole truth, and nothing but the truth?
I do.
Thank you. Ms. Tatum, go ahead.
Yep, for the record, my last name is spelled C-R-A-N-E.
Okay, Travis. We're going to try to be quick for you. Again, you have stated your name for the record, and you've been sworn in, correct?
Yes, ma'am.
Okay. How are you employed?
I work for the city of Raleigh and have been since 2008.
Sorry. I thought you were
okay.
still recalling the last year. I know you've been here quite a while. And what's your current title?
Assistant Planning Director.
And can you tell the board what your various titles have been throughout the years?
Yes, ma'am. When I was hired, I was what was known as a planning supervisor. We used to call it senior planner. Then I was hired as the planning and zoning administrator once the UDO was adopted, and then assistant planning director in 2015.
Okay. Was there a time where you were the acting zoning administrator?
Yes, ma'am. It happened on a few occasions. When I took the job as assistant planning director, we had not backfilled my old position, so I served as the interim zoning administrator, and then most recently I served as the interim zoning administrator when Mr. Romea was on leave.
Okay. Are you familiar with the Raleigh UDO?
Yes, ma'am.
And how are you familiar?
I was part of a team that worked with the consultants that drafted the architecture of the plan, drafted the content and the language of the plan, and then ultimately carried it through the adoption process.
And what year was it adopted?
In 2013.
Okay, and what year did you start working on it?
Late 2008, early 2009.
Okay, and I think you said you were one of the drafters of
Yes,
that
ma'am.
document. Okay. Have you worked with the UDO regularly ever since it was adopted 10
Yes,
years
ma'am.
ago? Okay. Did you hear Justin's testimony?
I did.
Do you agree with his testimony that he presented to the board today?
I do.
Okay. I'd like to pull up, you can do that for me, Travis? Let's pull up section 2.2, I'm getting 2.3.1, which is slide 12.
Okay.
Okay, and you recognize that.
Yes, ma'am.
Is that a provision that was a part of the UDO when it was first enacted?
When it was enacted, yes, but I can tell you that the compact development option was added during the drafting phase. Initially, we had the conservation and the conventional option, and compact was added by staff and the drafting team before we went out to public review.
And just, again, do you agree with Justin's, just what's the purpose of it again? Compact development?
Of the compact development?
Yeah.
It's to allow for greater lot efficiency. Initially, it was to allow for greater lot efficiency with the trade-off of a 20% open space standard for the development.
Okay, and that provision that we've been discussing today, C, transitional protective yard, were you involved at all when that was being drafted and coming through the process?
Yes, ma'am.
Okay, and that gives, according to Mr. Romea, 3 options for the developer, is that correct?
That's correct.
And do you agree with that?
I do.
Okay, and if you are using the perimeter lot standards, do you agree that you go to 2.2 open lot to make that determination?
Yes, ma'am, I do.
Okay, and if you could turn to that quickly, which is slide 14. Okay, and the requirements, according to Mr. Romea, are area and width. Is that your understanding?
Yes, ma'am.
Have you ever had a different understanding?
No, ma'am, I have not.
Okay, has there ever been a requirement that there be any kind of plantings or buffers or any kind of protective yard if this particular option is selected?
Not with this particular option, but it is one of the 3 options that can be chosen.
Okay. Now, is it also, you're aware of missing middle
Yes, ma'am.
1.0, and the addition of the compact development option for townhouses in R4.
Correct.
Okay. And under that option, it's been the interpretation that 17 townhome lots are allowed on this particular site.
Yes, ma'am.
Do you agree with that?
I do.
Okay. All right. You have been here all day and maybe watched from home before and have heard the discussion about lot versus lots.
Yes, ma'am.
Okay. Can you explain to the board what your interpretation and thoughts have always been with respect to lot and lots?
Sure. So when we were drafting the UDO, we obviously had a former zoning code in place. We didn't replicate that code, but we used it as a reference. The former zoning code included a lot of parentheticals, lot apostrophe S, or parens S, for example. And when we worked with our consultant team, we took a very particular stance that we didn't want to overcomplicate the code. Where something was referenced in state law, we depended on state law, and then stripped out all of that superfluous language in the UDO.
So you were familiar with the statute 12.3, construction of statutes, plural and singular?
That's correct.
Okay. And you agree, do you agree that the reference to lots throughout the code generally includes the singular as well as the plural?
Yes, ma'am, I do.
Okay. Okay, so then just a little bit, okay, you did listen to Mr. Justices and followed along with the other plans that have been approved under 2.3.1 and the compact subdivisions?
Yes, ma'am, as best I could.
Okay. The examples that he showed, in your opinion, did those comply with 2.3.1 as well?
I believe it was Mr. Rometta's testimony that they complied with the
Okay.
regulations, yes.
And they would, as long as the area and width was met, right?
That's correct.
What would it mean if they had extra plantings on the open lot?
I don't know that it would mean much. As Mr. Rometta testified, the applicant is only required to show compliance with the base minimum standard. So anything above and beyond that is not counted by the reviewer.
Okay, and just one last thing, there's some emails that Mr. Rometta brought up where there was some conversations about, while Mr. Rometta was on paternity leave in the spring, maybe March of last year, about whether an applicant who was doing a townhome development, which was kind of new, could use an perimeter open lot standard to meet the transitional protective yard requirements of 2.3.1. Mm-hmm. Do you remember being involved in that conversation?
I remember the conversation only because I've seen the email, but I don't remember the specifics of what we discussed.
Okay. Is it your opinion that, do you agree with the ultimate result that was decided on, if you will, that option was available?
Yes, ma'am, I do.
Okay, and was that different than any understanding that you had of the UDO before then?
Not before that, no.
So, in your opinion, was the 908 Williamson, was the code, although everything might not be the same, was it a consistent interpretation with how the code had been interpreted in the past?
It's my understanding that it was, yes.
Okay. You got anything? That's all I have.
Anything, Mr. Birch? No? Mr. Justice?
Mr. Crane, good afternoon. Consistent interpretation. Can you identify one project where the perimeter lot consisted entirely of one HOA lot that did not have a vegetative buffer?
I can't, and that's only because I'm not involved in plan review.
So how do you know it's a consistent interpretation then if you had no involvement at all with the set of facts that are presented here?
Well, we have discussions, as Mr. Rometta explained, about how to apply the code regulations. And it's my understanding that we had consistently used the open lot as an allowed building type for these type of subdivisions.
Can you identify, in these discussions you've had, can you identify a development that again, one HOA lot around the periphery suffices with no vegetative buffer?
Again, I'm not involved in plan review, and I don't have memory of that.
Were you involved in the approval of Laurel Hills?
No, it was not.
Are you familiar with Laurel Hills?
I'm aware of the subdivision, yes.
It's an R4 compact subdivision, right?
Yes.
With a vegetative buffer all the way around the perimeter.
I believe that's correct.
At the same time, this is at the same time that Williamson is being considered.
They were in close proximity, yes.
You said, well, I agree with Justin's interpretation of the meaning of perimeter lots, I think, right?
That's correct.
Do you have a dictionary definition that says that lots would be a singular lot? Have you looked up that at all?
I can't say that I have.
So what is it that you're falling back on for purposes of saying that the term perimeter lots is a singular lot?
Well, as I stated, when we started drafting the UDO, we made an attempt to remove language that we felt was extraneous, and we reviewed the state statutes and tried to pattern our language after that.
So Article 12.1, which is the interpretive code section of, sort of, if there's a term that needs to be interpreted, here's how you go through it, right?
That's right.
It doesn't incorporate rules of construction of any state statute. Would you agree with that?
I think we've testified to that before. And all I'll say is that we use the state law when framing our regulations.
So my question was fairly specific, and I don't sure I got a yes or a no. Does Article 12.1 specifically incorporate state statutes rules of construction?
It does not say those specific words, no.
Yeah. In fact, what it says is if there is a term that's defined in a state statute, that you can use that to aid in construction, right?
I believe that's correct.
And to your knowledge, is the phrase or the term perimeter lots, is that used in any state statute?
I can't answer that. I'm not sure if it is or not.
Do you have any experience as it relates to development of property?
As an actual developer? No, sir.
Okay. I'm assuming you've approved a lot of development projects, right?
No, sir. I don't believe that I've ever been a part of the approval process in the city of Raleigh.
Okay. So you wouldn't know how expensive it would be for a developer to have to comply with a B1 or B2 vegetative buffer, right?
Generally not, no.
Okay. So looking at this email from Keegan McDonald to you in April.
I don't have those up here.
Mr. Chairman, I was going over them with Justin, and they were all up there with him. Justin, can we go off the record? Yes, grabbed a bunch of them. Those are all originals, so yeah, you need to leave them up there. Thanks. Let's see here. All right, this is Exhibit 20, and there's an email chain here where Jason Meadows is asking Keegan and Eric Hodge the very question, or one of the main questions here, which is, does this singular HOA lot around the perimeter suffice? And Keegan is saying it doesn't. Do you remember that answer? That Keegan is telling developer at that time that the developer would have to put in a vegetative buffer?
I only remember the answer because I'm looking at the answer now. I don't remember the conversation that we had.
Yeah, but the answer at that time from Keegan was that the HOA lot would not suffice. The developer would have to put in a vegetative buffer, right?
Well, I believe the question was referring to townhouse developments.
This is a townhouse development. So for this
That's
particular
correct.
development, as you can see from the first email on the chain, Mr. Meadows is asking, does a singular HOA lot around the perimeter suffice to not have to do a transition protective yard? And Keegan's answer was no. I told him that they needed to put in a protective yard. Isn't that right?
I think that's what the language says, but I believe that what's missing in context here is that at the time, I'm not certain that townhouse lots were permitted in R4.
Townhouse lots are not permitted as a conventional.
Correct.
So the only option was to do a vegetative buffer. Have you been privy to listening in on these other comparable developments that where they were compact or conservation?
Yes.
And in the instances of dealing with the perimeter where there's a lot, we're talking about for single family detached. In the prime example is this Brindley Manor. The perimeter lots around this perimeter are for the same type of structure that would be to the interior. It's just they're on larger lots, right?
It appears that way, yes.
And so for a townhouse development where you couldn't have conventional townhouse lots, it makes sense that Keegan would say, well, there's no conventional townhouse lot, so you have to do a vegetative buffer. Doesn't that seem reasonable?
I would agree that's what the email says, yes.
And so as you sit here today, when you were saying, Justin got it right, Justin got it right, Keegan is informing you of the decision, and you can't tell me what had happened after that email where Keegan is telling you what he told the developer.
That's correct.
And you don't have any specific recollection of any meeting with Justin, Keegan, Eric, or anybody else?
No, I don't have any specific recollection of meeting with them.
Any specific recollection of an email where there's a deliberative process of how are we going to change what Keegan said? Any emails about that, to your knowledge?
Not to my knowledge.
Okay, that's all the questions.
Thank you. Before we move on, we're going to take a break. You've been patient, but I think we need to take 10 minutes. Re-adjourn at 3 o'clock, please. Ask questions at this time, if there are any. No? Okay, then, well, you have a question, you can ask it, it's allowed or it's not. We just,
You'll tell me if it's not.
we'll be, go ahead.
Just one question for you. When you have a question about what controls versus a North Carolina statute and what the ordinance states, you go to the legal counsel in the city?
Usually that's the first stop. Yes, ma'am.
Okay, and you're aware of the statute we've been discussing that talks about the same issue, the rules for construction of statutes?
Yes, ma'am.
Are you familiar with that?
Yes, ma'am.
Okay. And how would you think this would affect the question we have about lot versus lots? I mean, if an ordinance says a lot, it could still mean lots based upon this statute, right?
Based upon the writing of the statute, yes, ma'am.
Okay, thanks.
Other board member questions? Ms. Tatum, any cross?
No, sir.
Mr. Birch? No, sir. Ms. Crane, you're released. Thank you very much.
Thank you.
Ms. Tatum, do you have any other witnesses?
I do not.
Okay.
I would defer to Mr. Birch.
Thank you for reminding me. I was about to skip right past. Mr. Birch, please.
Mr. Chair, in the interest of time, we've had 2 witnesses ready to go at the last 4 meetings, but in the interest of time and given the evidence that is already in the record, we are not going to present any witnesses. We would ask the board, again, to help maybe give us, it's just after 3 o'clock now. Our goal is to get through rebuttal, closing if possible, but in that vein, we are not going to provide any witnesses.
Okay, well, thank you. We appreciate that. In that case, Mr. Gallup, let me be clear on where we are. I know that Mr. Justice had subpoenaed some folks. Where do we go? Do we go back to him at this point? With both parties have presented their cases? Do we go to closing arguments?
Mr. Justice should have an opportunity to provide rebuttal evidence, although it should be limited to rebuttal of evidence and arguments that have been presented in the case. He shouldn't have an opportunity to re-initiate his direct. So
Okay.
That should help us limit the time frame this afternoon.
Thank you, Mr. Gallup. Mr. Justice, that leads us back to you then.
Well, I do want to understand who's in the room, because I don't think with all due respect, should be limited in terms of order. I've subpoenaed 3 folks
Yes, sir.
to appear today.
Yes, sir.
I don't know them by facial recognition. So the first names are Jermont, Eric, and Keegan.
They're here.
They're here, sir.
Awesome. I think for purposes of, I think I said I would go with John Solic first, just make sure we get him in
Sure.
today.
Okay.
And Mr. Chairman, it would be nice to get an understanding of schedule. We purposely had 2 dates just in case, and the 14th was a time that I've blocked off just in case. So in terms of how far, and we're talking about next Monday, so how far into the day are we talking about going today? It's 3 o'clock.
I cannot speak for the full board. I think it is certainly my interest to, if we can finish. That would be most desirable, even if it means going until 6 o'clock. But I cannot speak for the board if they have commitments or if there's some anxiety about having such a long day. We do have Monday reserved, so any sense from the board, we'll just play it by ear. I can't give, like you can't give me an exact answer. I'm afraid I can't give you an exact one. We're going to push forward and try to be expeditious, but if we don't finish, we'll be back on Monday. Is that fair?
Sure, that's fine.
Okay, thank you. And if you would please introduce yourself and give us your address.
John Solic, 912 Williamson Drive.
Do you swear or affirm the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Solic. Welcome.
John, you are one of the appellants in this matter, right?
Correct.
Yeah. And although you weren't here, did you, I believe you were in Utah when Mr. Chappell testified, is that right?
I was.
And did you, in terms of hearing his testimony, did you hear his testimony?
I did.
Okay. Now, he had asked, there was a question asked Mr. Solic, Mr. Chappell, of whether or not he had met with the Solics. And his answer was, I believe members of our team have spoken with all the appellants. So can you talk to the board about that, whether that is accurate or not?
It's not correct. Not a single member of his team ever spoke with us about the property, about the development. I listened to him testify under oath that they met with all of the neighbors, all the appellants, the Post, the Bennett's, and us. They never reached out to us. They never met with us. He never met with the Posts. He did not reach out to the Bennett's. The Bennett's reached out to him. So the presentation that they tried to work with the neighbors in good faith was totally disingenuous. Nobody spoke to us. I have spoken with one of the owners of the LLC that owns 908, Nathan Singerman. Totally different interaction. Nothing to do with this property.
And what was that interaction?
He was the owner of my house. He sold me my house. He was the selling agent on my house. He was under contract to buy 908 2 days after moving out of my house. No interactions about the project, and no interactions afterward about working with us on the borders of the property.
Now, Mr. Chappell had talked about a desire to potentially put in vegetative buffers and whatnot to I guess, placate or mitigate the impact on your property. Did you hear that testimony?
I did.
Let me show you what I mark as Exhibit 46. Is this a copy of a written statement you prepared regarding your opinion about the impact of this project on your property?
Yes.
Mr. Chairman, I'd like to introduce Exhibit 46.
I'm not going to say anything but object for the record because this is a standing thing and not in rebuttal to anything we did on direct. So, and we probably need a copy.
Mr. Gallup, anything?
Definitely get you a copy.
Mr. Gallup, any thoughts on this? You've expressed opinion early, but
I don't have a copy of it to look at. I don't know what it is. Is
Okay.
it the affidavit of Mr. Solic from before?
Standing affidavit.
The same standing affidavit, Mr. Justice?
It is. It's already in the record.
that was part of the standing discussion.
Thought it was objected to and sustained.
Standing is a constant jurisdictional question. Even at the trial court, I'll be able to get in this. So there's been testimony already about this. This was attached to Jeffrey Brown's affidavit. So I'll be able to get this in one way or another.
This was the one that we discussed last time, was
because he wasn't here.
Well, but it was okay, not for the truth of the matter asserted at the time, but was okay as whatever assumptions that the expert used it for.
Because this gentleman had a prearranged vacation in Utah,
I
could
remember.
not be here.
I remember
and so
that.
now we're here.
Right, but
And-
to say that it's in evidence and an exhibit is not the same. I mean, are you using it for the truth of the matter asserted?
He's here. Of course I am.
Okay.
I had Mr. Chappell offer up all kinds of bells and whistles to try to mitigate the impact. So he is talking about the impact.
And she's objected.
Yes.
And so we're trying to decide whether or not to let an affidavit in when there's a person here to testify.
But we've had multiple affidavits already tendered. They submitted affidavits of every witness they had.
Did you object?
No, not to the affidavit, other than
They
that they couldn't give a general opinion about questions of law, but not to the fact that they used an affidavit.
Okay, but they
My
objected.
other point was what's it in rebuttal to if it's standing because that hearing is closed. That's the only thing I'm saying. And I understand he's saying he can admit it at the trial court, but I'm just trying to move things along because you were specific that it was only in rebuttal to what we did on direct.
And all I'm trying to do is, we're not legal experts up here. We're citizens trying to understand how to move this process along. We don't want to impede anyone's opportunity to get something forward that needs to be forward. We know this will go to appeal. We're not deferring to that, but we would like everyone's help, knowing that we're kind of limited here to let's get to the answers so we can resolve this.
I'm good if it's on the record. I just
Thank
don't
you.
think it's the time.
Thank you. Mr. Justice, go ahead.
Literally, I've
Sir,
got
go ahead.
1 minute of questions,
Go
and I
ahead.
was going to be done.
Yes, sir.
John, does this written statement accurately reflect your opinion and recitation of what you believe to be the facts of how this proposed project will impact you and your property that's adjoining this development?
It does.
That's all the questions I have.
Thank you. Okay, Ms. Tatum?
I'm going to defer to Mr. Birch right now.
Thank you. Couple of things, Dr. Solic. First, you've heard a lot of the conversation today about lot versus lots. Are you aware that we can just split the open space, the open lot, and comply with Mr. Justice's argument of 2 lots?
Objection. It's not actually in evidence as a factual matter.
Okay.
I'm not aware of that. I'm not sure that you can.
Okay. Let's say this. If we could split that one open space lot, if we could, would that satisfy you?
When you say split the lot, what are you actually referring to?
Right. The open lot, the lot 18, the large lot that Mr. Justice has colored in there, is a single lot. And Mr. Justice's argument has been that that's just a single lot and not 2 lots. And so what I'm asking is, if we were to split that into 2 lots, everything else being the same, does that address does that satisfy you?
I'm not sure that it does. I don't know I would have to see the plans. I don't know what that looks like.
Okay.
Are you referring to putting in a B1 or B2 transitional protective yard? Is that
So
what
right now
you're
I'm just
referring
talking
to?
about the perimeter lot.
I'm asking you, when you're saying split it, what are you referring to?
Yeah, so splitting would just be, on this topic, splitting it would be taking that one single lot, putting a line somewhere, and making it 2 lots.
I don't think that changes anything about our position. I don't know what that would look like, so I can't answer that.
So secondly, you said that you had listened in or had watched Mr. Chappell's testimony. Is that correct?
Correct. Part of it, I was listening remotely as best I could.
Right. And so the part that you were listening to, did you hear the part where he offered to provide a type B2 buffer?
I did.
And
so a B2 buffer, to my understanding, is 30 feet of distance from the property line to where their development starts. Is that correct?
no, sir.
That's what a B2 buffer is in the UDO.
No, sir. There's again, what we're talking about is a B1 or B2 buffer that is compliant with the code. And that is what was offered by Mr. Chappell at the last meeting.
Is that a B1? Can you bring that up? The definition of B1 and B2 buffer? Did he offer to put that along the entire perimeter of the development?
Yes.
Okay, so can you pull up the definition of that so I can understand what that is?
Yeah, we will see if we have it in that slide. I don't believe it's in the slide deck.
My read of the UDO was B1 buffer is 20 feet with a 6.5 height wall. B2 buffer is 30 feet with a 6.5 foot high fence. So is that what he offered?
Yes, the offer was what would likely be a type B1 buffer. It has a average minimum width of 20 feet with a minimum 6.5 foot tall wall. It also has a requirement for certain shade trees and understory trees and shrubs.
So are you telling me that he offered to put in a 20-foot wide buffer along my entire property line?
Yes, he offered to provide a type B1 buffer.
It's not what I asked you. Is he going to put in a 20-foot wide buffer along the entirety property line? Not an average.
Well, again, so the type B1 allows for an average.
Okay, then until I see the plan, I can't answer that question.
Okay.
If he's willing to put 20 feet along the entire line with a 6.5-foot wall, I will look at that and consider that. I'm not sure that he's willing to do that.
Okay.
So is that what you offered?
What was offered was a type B1 buffer.
I would need a better definition of what that is to be able to answer that question.
Okay.
Because if it's an average, you could put a buffer of 60 feet at the street level, and then he could go to that 4-foot distance along my property line. And if your average comes to 20 feet, it would be compliant.
No, the average can't be less than 1/2 of the requirement. So the narrowest it could be would be 10 feet.
I'd need to see the plans to answer that question. Nobody has offered that to us. He testified that they reached out to us, which was false. No one has discussed.
On that part, well, it was explicitly offered at the last meeting.
No, he testified that before then, they reached out to us. That's what he testified.
That was one part of his testimony, and then I asked him directly at that time, Mr. Chappell, are you now offering them a type B1 buffer? And he said yes.
No, that was never communicated. We are always willing to look at.
I've communicated that to your attorney.
Well, to be honest, every interaction that I've had with the city staff and the developer, this entire process has been covered in dishonesty. So I don't trust a thing until I see a concrete offer.
Okay. So let me ask you about communications. I heard what you said. And just on that point, were you aware that Mr. Chappell was in communication with Terry Henderson?
No.
Were you aware that Terry Henderson held himself out as a liaison between the development team and the neighbors?
No.
And were you aware that Mr. Chappell, through Mr. Henderson, offered to meet with any and all of the neighbors?
No.
Okay. Thank you. That is all the questions I have, Mr. Chair.
Thank you, Mr. Birch. Sir, anything else?
John, until you see it on a set of plans, this buffer that Mike keeps talking about, until you see it on the plans, it gets vetted through the city approval process, you have someone look at it, would you say it's premature to say it works when we've been spending at least 3 days saying we don't agree with what the city has done, right?
Correct.
So there's a lot of stuff that has to happen before you would commit to anything, right?
Without a doubt. I've seen, in all my interactions and in the testimony today, I've seen a city staffer who appears to be the czar of everything here, Justin Romea. He can't remember some conversations and he can remember others. He can look at a map here and read a distance of 300 feet. He can't look at that and look at a 2-foot distance between a driveway and my property line and say whether it's open space or not. So to say that my trust in their capabilities is low is an understatement. So I'm always willing to consider that. But every step of the way, I've seen dishonesty and incompetence from the city department.
That's all the questions I have.
Okay, thank you. Thank you, Mr. Solic. Okay, you may continue your presentation.
Thank you. I'd like to call Eric Hodge.
Mr. Hodge. Your full name for the record, please.
Eric Shane Hodge.
And do you swear or affirm the testimony you will provide will be the truth, whole truth, and nothing but the truth?
I do.
Thank you. Continue.
Good afternoon, Mr. Hodge. Have you been listening in or privy to the hearing, the other dates we've had?
Most of it, yes, sir.
So
Sometimes I take bathroom breaks when they're not taking them.
That's fine. But you're generally aware of the testimony given to date?
Yes, sir.
Okay. So you were listed on a number of communications. I think they're in front of you that I'll ask you about. All right, I'm going to pull out that one. And I'm going to pull out. This is 20 and 24. And 26, I believe. Yep. All right. So, Eric, in terms of your job responsibilities for the city of Raleigh, if you can just, when did you start working with the city of Raleigh?
March of 2004. So almost 20 years ago.
And just walk me through sort of what your job responsibilities have been during that period of time.
For about 9 years or so, I did plan review, approving subdivisions and site plans, some of which at that time were administrative in terms of subdivisions, and site plans mostly were ones that went to Planning Commission and or City Council for final approval. And then around tail end of 2013, beginning of 2014, I started working with the Board of Adjustment on cases that came before this board, as well as text changes to the newly adopted Unified Development Ordinance, which was adopted in September of 2013. And at the tail end of my plan review work, I was the lone plan reviewer that was sort of on the UDO team, bringing forward. It was sort of a marriage of one type of code and some elements of our former code. And so they wanted people who had familiarity working with the former code on that team.
So from after 2013, you said you've worked for the Board of Adjustment, you involved in text changes. Are you in the zoning administration department?
Yes.
Okay. And tell me, in terms of your responsibility specific to that, is it just giving advice to the Board of Adjustment in doing text changes, or is it more than that?
It's assisting customers with sometimes understanding what the code requirements mean, and or staff who are implementing new changes that we have worked on through the text change process.
Okay. So in the exhibits that I've given to you, there are 3 exhibits, 20, 24, and 26. There is an exhibit in a chain of communications where Jason Meadows, who's the developer representative for the Williamson project, you understand that, right?
Yes.
He reached out to you and Keegan McDonald and posed the question about whether a singular HOA lot around the border of this property would suffice in lieu of a vegetative buffer. Do you remember that correspondence?
I don't remember it, but having heard reference to it a lot during this meeting and previous meetings, I have become aware of these emails.
And so you recognize Exhibit 20 as
Yes,
a
sir.
communication? Mm-hmm. And at the end of the day of that communication, Keegan McDonald is reporting that he informed Jason Meadows that the answer is no, that a singular HOA lot as proposed would not suffice for a transition protective yard, right?
Correct.
Meaning that he would have to, that this developer would have to put in either a B1 or B2 buffer, right?
That's what the email appears to say.
All right. So did you have, since the email was directed to you and Keegan asking the question, let me start with that. Why are you being asked to give this answer?
So at that time, Justin Romea was on paternity leave, and we were the other two people that work in zoning administration. And a lot of times we know the answer because it's been asked before, and so we sort of know the historical answer, or we can shed light on something that may be uncertain to other people from the public or staff. And then there are some times where we really don't know what Justin may or may not say because it's not been directly asked. And so in those instances, we typically bubble it up to Justin. But in instances where we've already kind of had a discussion about something, typically, I would go ahead and offer an answer. I did not respond to this chain of emails because it was a new regulation, and so I didn't feel comfortable setting forth an understanding for something that had not been reviewed or commented on directly by the zoning administrator in a prior similar situation.
Well, it appears that Keegan is responding.
He may have had a conversation with Mr. Crane, who was at that time acting zoning administrator. I did not.
Well, you had said that if there had been a historical application relating to the issue, then that would be an easy call and you would give it. So are you saying the question that was posed by Mr. Meadows, it wasn't, to your knowledge, have been dealt with before by the city?
I wasn't aware of any of those conversations. Again, the compact development under this missing middle one option as of March of last year was relatively new, and I had not seen any compact developments reviewed or approved under it, but I don't typically see plans on a day-to-day basis unless there's a question. You asked one of my duties, typically that we have a sort of internal powwow get-together. If there is a question and it's sort of scattershot approach, everybody sort of spitballs or throws in their opinions or thoughts, sort of a catch-all, and ultimately Justin Romea, the zoning administrator, typically, makes the final decision. But oftentimes he, factors in those comments to formulate, a final opinion, trying to get all sides, or someone plays devil's advocate internally just to, make sure that everything has been thought through before a decision is rendered.
Well, the issue about how to apply a transition protective yard in the sense of either, in the testimony has been there's three options in the context where that standard is triggered, either put in a B1 or put in a B2 or do perimeter lots. You understand those three options have been testified to? So that standard has been in place, if you heard it today, listening to Justin, has been in place at least since 2013 as it relates to conservation developments, as well as compact developments. Yes?
Correct.
And if you listen to today what was said, that there's a number of conservation or compact development approvals that have gone through the gauntlet that have touched on the topic of a transition protective yard with vegetative buffers or perimeter lots, right? Mm-hmm. You're saying that this issue never came up about, in those instances, in your recollection, of using a singular HOA lot around the entire perimeter with no vegetation to suffice for that standard?
I can't recall any, but I don't see things that are going through the meat grinder of plan review and coming out with approvals on the other end, unless there is a question that is brought to our sort of internal standing meeting on a weekly basis. And I can't recall any instances where that has come forward.
Okay. So in the standard, you understand that here, for this Williamson project, and right here is this is Exhibit 6. There is no B1 or B2 buffer around the perimeter, right?
It does not appear to be.
Yeah.
Because there's no landscape plan. So.
Yeah. So, so the only other option would be perimeter lots. To To your knowledge, has the term perimeter lots ever been interpreted before? What that meant?
I've not been part of any conversation discussing lot versus lots.
Okay. Now, Keegan is giving an answer that because a townhouse, there's not a conventional lot for a townhouse in R4. The only option is to do a vegetative buffer. That was an answer given in April of 2022, right?
Per these emails, that's correct. From what's
Okay.
been communicated.
So you don't recall any specific discussion with Keegan before he told the developer applicant that answer?
I don't recall even he and I discussing it, let alone any involvement with Travis Crane. I was not part of those.
Okay.
Other than seeing the emails pinging and ponging back and forth, I was not part of any conversation on that point.
Well, pinging and ponging emails.
Which is not unusual.
Yeah, sure. I don't. It's easy to communicate via email. So when you say pinging and ponging, did you recall an email from Justin dealing with this topic?
I do not.
Do you remember an email from Travis Crane dealing with this topic?
I do not.
Where you were saying pinging and ponging emails. So what are you,
Well,
between
in terms
who?
of between Mr. Meadows and Keegan and the emails you've put forward here. I mean, there's a few. It's not just one or two emails. So that's why I use the term pinging and ponging. I'm just watching, them go back and forth, but I'm not communicating because I'm not part of the conversation. I don't take on every email that comes to me that may also be sent to a colleague of mine. That's not judicious of my time for multiple people trying to chase the same rabbit. So we got a lot of rabbits.
I understand. So did you ever get into a communication either via email or in person with Justin regarding this issue?
I don't recall me commenting on this issue at all up until around July 20th of last year when this plan came forward at an internal meeting for my first viewing, and then we sort of bounced generally down sort of a checklist of items that the compact development, needs to subscribe to, involving most of these gentlemen that have been called. And that was my last time really seeing or hearing anything about the project in a capacity where I could contribute.
So you said you were part of an email chain where it was subscribing to what the compact subdivision should involve.
It wasn't an email chain, it was a meeting, and we just sort of talk about the plan, what is this plan, what's it being reviewed under, is this missing middle 1, is this missing middle 2? Because missing middle 2 had been, I believe, adopted, but was not yet in effect. And I was involved with missing middle 2, more so than missing middle 1. And so we were all there to sort of try to figure out, and ultimately I think I recall looking at the cover sheet of the plan and noting to staff, this is a compact development. That's what it says on the cover page. So we should be reviewing it under the compact development regulations.
Who was in this meeting?
I can't say with certainty comprehensively, but I believe Daniel Stegall was in the meeting, Jermont Purfoy was in the meeting, myself, Keegan, and probably Justin Romea, but I can't say with certainty.
So and you said this was probably after Middle Housing 2 was adopted?
Adopted, but not yet in effect, because it was adopted, I believe, in May and had an effective date sometime in early August. And so this plan was in review, and I believe in July for the first round of staff review. And so we were trying to make sure that the plan reviewer at the time, Mr. Purfoy, who's here, was covering all his bases and doing due diligence and raising issues and whatnot if there were outstanding concerns with the plan.
So let me show you what I'll mark as Exhibit 47. Exhibit 47 is a copy of missing middle housing 2, right?
Correct.
And that's adopted in July.
I thought it was in May, but I could be mistaken. I thought it had an effective.
Well, I'm sorry. It does say adopted May 10th, 2022.
Yeah, as I recall, there was a special meeting because of COVID. I think a council meeting had to be postponed, and there was a special meeting called on May 10th, if I'm not mistaken, during the day in which this was approved. Mr. Pacini might be able to confirm that for me, but that's my recollection. I was out of town and had to rush back to be back for that meeting.
All right. I'd like to introduce this exhibit into the record, please.
47, correct?
Yes.
Thank you.
So this place is, because as you can see, this ordinance is adopted early May 2022, and become effective to August. So this place is, from a timing standpoint, that you're in a meeting with other staffers talking about this Williamson project, right?
Correct.
And at that meeting, is there a discussion about the fact that Keegan has answered this question that about can an HOA lot suffice as in the negative that a buffer is required, a vegetative buffer?
I don't recall getting that specific, and let alone that this has been answered in some form or fashion prior. Again, it was my first seeing of the project, as it was, I think, most people in that meeting, with the exception of Daniel Segal and Jermont Purfoy, who had seen it prior to. It just, I was there, and here it was in front of me, and we're just sort of thinking, off the cuff, what is this? How is it to be reviewed? What regulations apply? Did they jump the gun, and are they trying to apply missing middle 2, which is going into effect in about 2-3 weeks, or not? And we were sort of uncertain at that point. And so that's my recollection, that most of the conversation was kind of focused on what is this thing and what regulations do we apply? And then we sort of went through that exercise and then kind of covered the generic bases. What's your primary street? That sort of analysis. It's typical of a plan review. I don't typically do that plan review, but was, trying to give it the team effort to knock some of these questions out, in our initial conversation.
Well,
because staff had not sent comments yet to the applicant.
Well, in that conversation, looking at Exhibit 6, everything in color, the orange, the pink, the black, that's labeled as one lot, Lot 18.
Correct.
So in those discussions...
The orange, the pink, and the black, right?
Orange, the pink, and the black, yes. So in those discussions, are you discussing whether or not what's in color here that suffices as perimeter lots for a compact development?
I recall that was something a question was being put out to the applicant as to how they were meeting that requirement. I don't know that we solidified whether or not it did or did not satisfy it, but I think for the record, the reviewer wanted the applicant's confirmation about which of those approaches they were utilizing.
Well, is there an email that would kick the question back to the applicant?
In the review comments, I don't know if that was one. I can't recall. I have seen the review comments. In fact, you sent them here, but I haven't looked at them in a long time.
Well, the review comments doesn't kick the question back. The review comments lay out for this particular developer a choice of doing a vegetative buffer or one open lot in the review comments.
And see, again, my conversation was on the 20th. I don't know the date of these review comments. Do you see the date there? Those seem to have been sent in September. So after the 20th, I was out of the loop.
Okay. So did you...
One and done.
All right. Well, Mr. Hodgej, did you ever give an opinion about whether or not, from your perspective, what you're seeing there in color met the meaning of perimeter lots?
I had never seen a development of that type. I do understand Mr. Romea's position relative to the term B1, B2, or perimeter lot. That's debatable. I'm not here to answer that lot versus lots question. I never had a conversation about that. But I do see where the code says, a lot's width is met at the street and whatnot. And so I do see that this technically meets, a perimeter standard lot requirement.
And that's what you communicated at this meeting, or do you remember even?
I don't remember really talking about it so much during the meeting. Again, we were talking about everything about the project. It wasn't focused solely on this transition or buffer yard.
So you involved in text changes. You've been with the city since 2004. What is your understanding of the whole point, the purpose of a transition protective yard?
I believe protective yard is a defined term in the code. Transition yard is a type of protective yard. I don't have that definition put to memory, but somebody wants to pull that up, I'd be happy to read it. But there are various types of protective yards. In theory, they're intended to buffer between either different uses or different types of developments.
Okay. Well, I was asking you what you understood the purpose of it was, and that's to buffer different uses.
Or types of developments. That's my understanding of a protective yard.
So using that, how does what's shown here on Exhibit 6, how does that, what's shown accomplish that purpose?
Objection. That's not relevant, not within his purview to opine about what the purpose of something is.
Can you answer that?
All I can say is what the code says, that this transitional protective yard requirement for compact development or other types of developments are, and in this particular instance, it's the B1, the B2, or the traditional or conventional perimeter lots.
How is what's shown there in pink and black, that's around the perimeter, right? That's the part around the perimeter.
Mm-hmm. It's the fact that it conforms at the street is what I think ticks the box for the city. That at the street, and the fact that it's all contiguous and is one lot, or could be two, the fact that it is part of a conforming lot satisfies that code requirement in the black and white.
Oh, so in the black and white. So this is 65 feet width at the street, right?
Correct. And it goes around the entire periphery of the development.
As it goes around the entire periphery, it could be a foot wide, it could be 2 inches wide, as long as at the street it's 65 feet. Right?
As it's been decided, I believe, by Mr. Romea in testimony here to that fact, yes.
So why would a developer, if that was the case, that the developer could just simply go to the street and have a 65-foot width of an open space with trees as they go around the whole perimeter of the project? Why would the developer always just connect it to that street and have this snake go around all the way around the perimeter and basically be an inch wide, or, you know what I'm saying? Why ever put
Objection.
in vegetative buffers?
It's just,
He can't suppose what a developer might think.
Oh, it is it's a common sense question, Mr. Hodge. Why would, if that interpretation is the controlling one and the correct one, why would there ever be a vegetative buffer at all?
Well, I think in some instances a developer can't do a 65-foot wide lot out at the street or streets and then snake it down. There are some instances where perhaps that is not geometrically possible. In those instances, I wouldn't think they'd have that option.
Oh, okay. So does this provide any buffer to my clients?
I mean, there is some separation between the units and your client's property.
All right. And so as you sit here today, this question about what the meaning of perimeter lots is, you are not aware of the city ever tackling this issue before?
I'm not.
Yeah. And in terms of determining lots, you're a zoning administrator, right? Article 12.
I work under the zoning administrator.
Understand. But you understand Article 12.1 sets out sort of here's a term I'm supposed to interpret, and here I walk my way through Article 12.1, right? Mm-hmm. Yes?
Correct.
And if it's not a defined term in the ordinance, and perimeter lots is not a defined term, right?
Not that I'm aware.
You go to a dictionary definition.
That's my understanding.
And do you understand that the dictionary definition of lots would be plural?
Objection. If he's looked at the dictionary,
I haven't looked at lot versus lots, but I typically understand an S means more than one.
Yeah. Those are the questions I have.
Okay, thank you. Ms. Tatum?
just a couple of questions. Mr. Hodge, I think you've stated you're not the zoning administrator. Is that correct?
Correct.
And I think you testified on multiple times that you were not really involved in the question that is before the board today, which is whether you can use a perimeter lot such as this to satisfy 2.3.1. Is that correct?
Correct. I was never part of those conversations.
And any emails that you had or were involved in would not be binding in any way on the zoning administrator. Is that correct?
Correct.
Okay, I don't have anything further.
Mr. Birch, anything?
Just two items, Mr. Chair. First, Mr. Hodge, I believe Mr. Justice showed you what's Appellants Exhibit 20, that email. Can you tell me the date of that email?
Well, there's a few dates, but March 6th, they started on March 14th of 2022, and the last one is on March 17th of 2022.
Great, and I believe the application's in the record. So are you aware that the actual subdivision plan was not filed with the city until June 21st of 2022?
I didn't know the filing date, but I do recall first seeing it in July, and I believe of 2022 before comments went out.
Great, perfect. That's all I have. Thank you.
Thank you.
Eric, one of the emails you had, you said you weren't really part of the loop. Why are you getting an email in September from Catherine
Wilson? Mm-hmm. Just to see what the applicant's responses were to our initial round of comments, because this was the first type of this project I had seen. And again, having worked on Missing Middle 1 and 2, just wanted to kind of get a feel for how this is going through the process.
And the applicant's response to the question about whether there is a vegetative buffer or perimeter lots, do you recall what the applicant's response was?
Do you know which number that is? I don't recall. There's a lot of them. 21. Okay, let's see.
What is the applicant's response?
Should I read what the comment was?
Sure.
So the comment was sheet LA1 per the compact design standards noted in UDO section 2.3.1.c, a B2, a B1 or B2 transitional protective yard per section 7.2.4, or meet the open lot conventional design standards in section 2.2.6. If you are applying future text amendments or changes, that's fine. Please note in the data table information in sheet LA1. It would be suggested to provide some type of vegetative buffer outside the TCA areas along the perimeter lot lines abutting residential lots to the north and west. And then the applicant's response was acknowledged. As discussed, the proposed layout does not have perimeter lots directly abutting the boundary of the site. Rather, the common lot abuts all adjoining lots. Therefore, the transitional protective yards are not required.
So from that comment, Eric, is you read that, hopefully the way I read it, is developer applicant is saying we don't have perimeter lots and we're not doing a vegetative buffer.
They're saying that they can satisfy that requirement through a common lot abutting all external properties.
They're saying that we're not putting in perimeter lots, though.
That's word for word what it says.
That they're not putting in perimeter lots.
The proposed layout does not have perimeter lots directly abutting the boundary of the site. And I believe these are Mr. Meadows' comments.
Those are the questions I have.
Okay, thank you. Board members, I skipped right past you. Do you have any questions for Mr. Hodge? Okay, Ms. Tatum, did you want to follow up? Okay, Mr. Hodge, thank you very much for your time.
Thank you.
Okay, Mr. Justice, another.
I'm going to leave everything here in case you need to pass
Thank you
it
kindly.
off.
Thank you. I'd like to call Jermont.
Okay. I believe you have already been sworn, so that still applies.
I don't think Jermont's been sworn.
No? I apologize. Then in that case, do you swear or affirm the testimony you will provide with the truth, whole truth, and nothing but the truth?
Yes.
And just state your name.
Jermont Purfoy, Purifoy.
I heard your name mentioned so many times I could have sworn you were up here.
Good afternoon, Jermont. How long have you worked for the city?
23 and a half years.
23 and a half years? You look too young.
Appreciate that.
So, and if you would just run over your job responsibilities in that time frame.
I originally started out in the plat recording division as a planning assistant. Through the years, planning technician and planner one, and then I switched over to the switched over to the current land division as a planner two / then senior planner since 2017, 2018.
Have you ever had, putting aside Williamson project, have you ever had a development project where the transitional protective yard, as it relates to B1, B2, or perimeter lots, was satisfied by a singular HOA lot with no vegetation?
None comes immediately to mind in terms of a compact conservation. I do think we, in the recent year, have seen more townhouse developments come in. I don't recall the name of that development, unfortunately, right here, right now. But in terms of their internal private streets, it's not uncommon.
I'm sorry, what's not uncommon?
To see one HOA common lot being served for the whole entire site.
My question was, for purposes of satisfying the transition protective yard, B1 or B2, or a perimeter lots, have you seen a common HOA lot around the perimeter that doesn't have any vegetation?
I have seen that before.
Can you give me an example?
A townhouse lot which might have an internal private drive where there's residential lots and there's private drive in which the HOA lot would then be on one common lot.
And this is since when?
This particular project was probably a couple of years ago, if not within the last year.
So Laurel Hills is an example of a compact subdivision that was R4 that had townhouses. Are you talking about that one?
No, I'm not.
That one has a vegetated buffer around the periphery. Are you aware of that?
I've seen it before, but I'm not aware of the particulars of that particular. Wasn't the coordinating planner for that.
So the one that you're talking about, you don't know the name, and do you know where it's located?
I want to say around the NC State area. I just don't know the name off the top.
Is it a compact development or a conservation development?
I do not recall that.
Well, that's the key. If it was a conventional development, there wouldn't be no buffer requirement, right?
Correct.
So what you're talking about is you don't even know if it's a compact or a conservation development.
I just don't recall the specific design type at this time.
All right, let me show you what I mark as Exhibit 48. Exhibit 48, this is an email communication that you are copied on in July of 2022 involving Jason Meadows relating to the Williamson project, right?
Yes.
I'd like to submit Exhibit 48 into the record.
Okay.
So in this email in July of 2022 from Jason Meadows to Daniel Stegall indicates that Jason is forwarding his previous communications with Keegan, the communications were with Keegan and Travis Crane related to the applicability of this transition protective yard, right?
It says neighborhood transition.
Well, is there anything else, when it says neighborhood transition, is there anything else that it would be other than a
transitional protective yard and the neighborhood transition protective yard are two different yards.
All right, what is the neighborhood transitions protect?
Neighborhood transition yards typically involve mixed-use zone developments, such as a commercial development next to a residential development, which I believe has been noted earlier on.
Okay.
Transitional protective yards typically are applied to use standards, design standards pertaining to a site.
Did you receive the communications that he's referring to that between Jason Meadows and Keegan McDonald and Travis Crane? Did you receive them?
It looks like my name was CC'd on the email.
But this is dealing with transitional protective yards, at least the communications we've seen. Are you saying that this communication in July is about something else?
I don't know.
All right. Were you privy to any meetings with staff, whether it included Justin Ramada or anybody else, discussing the topic of the transition protective yard for this Williamson project?
Yes.
Okay. And when were those meetings?
The meetings were in September of 2022 during the second version review comments.
Okay. And the meeting, who was in the meeting?
This was a weekly zoning interpretation meeting, which is normal for our department. I believe the email was sent to myself, Daniel Stegall, Justin Ramada, Keegan, Eric, Nicole Ward, and Alicia Thomas.
I'm sorry, that was who was at the meeting?
Who was at the meeting? I believe all those participants were there except for Alicia Thomas.
And what was discussed?
This was a special meeting, I believe, in September the 20th. I believe Daniel and I corresponded September 14th to basically say, hey, we need to look at this plan that's come in for a second review. The meeting occurred, I want to say September 20th. I may be off on the date. And so this was a zoning interpretation committee meeting involving those participants to look at this particular case, and I think a second case was on the agenda.
And did the second case have anything to do with transition protective yards?
I don't know. That was not my case.
Do you keep minutes of these meetings?
No, this is an informal Microsoft Teams meeting.
Okay. So it's a Zoom. It's like a Zoom call.
It's like a Microsoft virtual meeting.
And so did you talk about the issue of whether or not a singular HOA lot as proposed here for Williamson would comply, so it would be sufficient to, in lieu of a vegetative buffer?
Yes.
Okay. And what was discussed?
Staff wanted to get an interpretation per section 1.5.1 of the UDO 1.5.2. Daniel Stegall and I previously discussed this on the first version comments in July 19th, July 20th, before the first version went out. We did not come to a conclusion at that point, so therefore that's why those comments read as such in terms of the landscaping, basically regurgitating what 2.3.1 of the UDO says. No determination was made at that point, but yet we were telling the applicant, basically, this is what the UDO requires and more time would be needed. And thus, at the September meeting, the question was posed and Mr. Ramada basically noted that per section 1.5.1 of the UDO, in terms of the definition of lot width, and 2.2.6 in terms of open lot, the applicant was required to have, I believe, a somewhere around 65 or 45 feet width, and meet the square footage requirements.
How long did this meeting last?
In terms of this discussion?
About this topic, yep.
I don't know.
More than an hour? More than less than an hour?
I wasn't looking at the time, sir.
Okay, all right. Did Justin identify any source for supporting that interpretation, like a dictionary definition or other cases where this had been applied, or anything other than just off the cuff his opinion?
I don't think it was off the cuff his opinion. He applied the UDO section 1.5.1, 2.2.6, and 2.3.1. Staff discussed previous plans, a previous plan that was recently looked at for a similar schematic design, Barwell Road townhomes.
Barwell?
Yes.
Yes.
Barwell.
Right. And what was discussed about that?
The same determination was made in terms of the applicants utilizing the compact development choice, which the lots were kind of interiorly being pushed in. It didn't look schematically like Williamson, but conceptually there were no perimeter residential lots. The lots were more interior, and there was kind of like open lot, open field area around the periphery of the site.
All right. Anything, and I was asking you off the cuff, and I apologize, it's, I guess, too layman. Did Justin refer to anything like a dictionary, like previous cases, or anything other than looking at this UDO and just then spouting off his opinion of various sections? Did refer to anything?
We diligently looked at this case in terms of applying what the UDO requires per those sections, as well as considering the Barwell development.
Okay. So your comments, you gave out the initial comments for planning? Is that
Correct.
right? So in July 2022, this is Exhibit 25, relating to this topic, why, you said we just basically gave a recitation of 2.3.1 because you didn't know the answer.
No answer could be determined at that time.
But that's not that's not how you listed your comment.
Correct.
Your comment was that you, at that time, said you could do a B1 or B2 buffer or a common open lot.
Yes, an applicant could do that.
Yeah. So why are you in July of 2022 saying those are your options when that decision had not yet been made by Justin, because that's in September?
Because that's what the UDO requires per 2.3.1C.
Based on what? Your reading of it? Because Justin's on paternity leave. So whose reading of it?
Based on what that says in the current UDO.
In the current UDO, 2.3.1.
2.3.1C, as has been noted here, notes that this is what is required per the UDO.
Perimeter lots is what it says. Yes?
Correct.
So why didn't you put the words perimeter lots? Instead, you substituted common open lot.
Because that's what was being proposed per the site plan.
Okay. So you're making a comment back that seems to be different than what Keegan's comment was merely 2 months earlier.
I was not privy to Keegan's comment. I don't know what Keegan's comments were contextually in reference to. I'm making my comments based on the initial review of the site plan.
So when you gave out your comments in July of 2022 with the exhibit that you're looking at, did you talk to anybody before you typed in your comments relating to this transition protective yard?
Yes.
Who'd you talk to?
Daniel Stegall.
Anybody else?
I think there might have been phone discussions with Mr. Meadows, but in terms of internally, Mr. Stegall.
Okay. And did you look at a dictionary definition when you were, or followed Article 12.1?
No, I did not.
Okay. Those are all the questions I have, Mr. Chairman.
Thank you. Okay. Ms. Tatum, Mr. Birch.
I don't have anything.
Okay, board members, questions for Mr. Purfoy? Thank you very much. Appreciate your time. Okay.
I don't have any other witness.
Okay. let me see. I think that gets us to closing arguments.
It would.
Okay, so I don't know if people had thought that we'd get this far this fast, so what I'd like to do is pose the question to both of you. Are you ready to give brief closing arguments that highlight for our benefit the essential points that we need to understand to be able to render a decision? Ms. Tatum, are you?
I am ready.
Mr. Birch, would you be ready?
Yes, sir.
Mr. Justice, would you be ready?
Yes, sir.
Outstanding. Mr. Justice, I believe you're up then, and thank you.
Thank you, Mr. Chairman, members of the board. I obviously appreciate your patience during this process. Our arguments deal with common sense, logic, and plain language. There are other arguments that I'll touch on about the consequence of the decision you make here. But we believe the ordinance is plain, and in the rush to champion middle housing, that the ordinance was overlooked. Or, let's put it this way, was put to the back seat, and this project was allowed to be sort of the test case, if you will. At the end of the day, the issue, the primary issue is whether or not this qualifies as a compact development. To be a compact development, there's a trade-off that occurs as it relates to protecting the adjoining neighbors. Now, you've heard from the record, or you saw on the record, where there was comments about what the whole point of a transitional protective yard was, and that is to separate inconsistent uses or building types. Provide a buffer. Provide a buffer. Just common sense, provide a buffer. And the options given in the code that apparently has been in effect since 2013 is either a vegetative buffer or perimeter lots. The Brindley Manor, I use this as an example of what it means to be perimeter lots. Perimeter lots, is, as you heard, was not a defined term. It's not something you can go into the code and say, oh, this is what they mean by perimeter lots. And so Article 12.1 instructs you to sort of follow a dictionary definition. The Hail Mary they gave today is to go look at a state statute that didn't even use the term perimeter lots to try to salvage this interpretation. But I would say if you look at any dictionary definition of lots, it's going to be plural. And perimeter, of course, means these lots are divided up around the periphery, the perimeter. And why do you have conventional lots? If y'all read our brief, we point this out, which is the whole point of a transition area is between a development where the developer is given a nugget of more density or a nugget of inconsistent types of buildings compared to the surrounding or adjoining properties. This nugget has to have a protective barrier around it. It has to have a transition barrier around it so that the neighbor is either looking at a vegetative buffer or looking at like-kind lots. That's why in the examples we gave you, if there was a perimeter lot, this is the Brindley Mountain is a prime example. These lots are conventional subdivision lots around this perimeter. Here in the nugget are smaller lots, more density. But the perimeter is protected from the neighbors because the neighboring lots are the same kind of size. So has to be the meaning of perimeter lots. And when you go through and you look at how it was applied in the past, since 2013, it has been sparingly used. The topic has sparingly come up. And why is that? Because conservation development required multiple acreage to begin with, required large pieces of property where a developer had lots of room to work, lots of room to put the pieces of the puzzle together. And that was 12 acres for conservation, and for compact, it used to be 8 acres. These were large lots. Developers got a lot of room to create a perimeter buffer, either vegetative or conventional lots. And so what happens in middle housing, in this rush to let's jam in more infill housing, is that more density can come out, but for R4, the transitional protective yard never changed. The council made a decision to change it for R6, but they kept in the protections of what's around the perimeter. And as we've put in the record, the whole point of that is to protect the neighborhood character, to preserve the character for the adjoining lot owner, to provide some sort of protective barrier. Exhibit 6 is not that. And so when you break down whether or not there is a perimeter lots around here, obviously there are no vegetative buffers here. And again, does this qualify as a compact development where we're going to give the developer more density in the middle because there's a trade-off with either vegetative buffer or conventional perimeter lots? And that's not what's shown here. And it has to be a trade-off, right? Because otherwise, why would the developer ever worry about a vegetative buffer? And this is a prime example of a consequence where if this is allowed to stand, why would you ever have a vegetative buffer in most instances? Because this issue comes up, according to this table 1.4.2, it comes up for every compact development, every conservation development, potentially every cottage court development. And this would even correlate to apartments in R6, what we're talking about. That literally, you could have apartments next to single density or low density development with this kind of quote unquote buffer that's not being provided. So the consequence of this is not just this piece of property and what can happen, but around the entire city of Raleigh, when somebody is trying to get a compact development or conservation development or a cottage court, what buffers are going to be required. We hope that this is not the answer. And so to break down the plain language of it is it requires perimeter lots. What's noted here, admittedly, you just heard the developer's response was, we didn't put in perimeter lots. That's from the developer's own words. We didn't put in perimeter lots. We put in a 1 HOA lot. And quite frankly, the HOA lot could literally be 65 feet at the road and 1 inch all the way around the boundary. Could be, if their interpretation holds. But these are not perimeter lots around this perimeter, period. Now, we also point out that except for the tree conservation areas, this space that you see that's in black, that road is not open space. That's a street, that's development. It doesn't meet open space requirements. This would not be a particular use of an open lot, a street. And so all you're left with is this little strip. And even the definition of open lot constitutes some large areas of open space. Typically, they are natural areas, they are parks, or they are traditional open spaces, whether they're primary, secondary, or tertiary. That's not what this is. And they admittedly did not hatch this in as qualifying for open space because it doesn't. And the examples we gave you over time from 2015, I think was the first development, in each instance, the developer is either doing conventional developable lots around the perimeter, or they're putting in a B1, B2, or there's this riparian buffer. And the examples they gave of, well, see, there's not a transition protective yard because this lot doesn't have a buffer. is a little bit laughable because the examples they gave are these riparian areas around the Neuse River, where there are, of course, 50-foot riparian buffers that are around these water courses, and those are vegetative. So, of course, they would be buffers and would not be just a strip of land potentially 2 to 5 feet in width before you get to the only road serving the development. We believe the plain language supports that this did not qualify as a compact development because there are not perimeter lots around the perimeter, nor is this a conventional open lot around this perimeter because it doesn't meet any of the qualifying uses for an open lot. It doesn't meet the definition. This is like me pulling my lip above my head and saying, isn't that normal? This is not normal, folks. This is, politically speaking, this is gerrymandering. This is just a way to draw lines of ownership that has nothing to do with, well, what's going on the ground in terms of use, function, and purpose. This serves no purpose other than to check a box to allow this developer to jam in on 2 acres, 17 townhomes. And the problem for them is this language that's meant to protect people had only been used in the past on large pieces of property, 12 acres or 8, where it was easy to put the pieces together and generate some density in the middle. When you translate it to basically infill development in R4 in a historic neighborhood where the lot size could be less than 2 acres. This happens to be a small lot of 2 acres. It just doesn't work to have a protective barrier around here unless you're going to put a vegetative barrier. That's the only thing that could work. So we believe that the fact that there's not been any type of consistent interpretation, that Article 12.5 seemingly wasn't followed. They didn't go to a dictionary definition. It is literally off the cuff. They come to you today, they say, well, what about state statutes? Well, that's not something that was considered back when this determination is made. And of course, that state statute deals with a rule of construction which this city has not adopted. Think about that. Slow down and think about the fact that they're saying that what the folks in the General Assembly has said is how you read an ordinance or how that you read a statute in a legislation that the folks over there at the Capitol building created, that is binding on how you read your ordinance based on your Article 12.1 steps of what you're supposed to do. And quite frankly, if the city of Raleigh wanted to say how the state reads their statutes the way we're going to read our ordinance, you would have said that, but you didn't. You said, let's follow common sense, plain language, and if there's not a definition, let's look in a dictionary. There is no other way to define perimeter lots other than it has to be multiple lots. We can sit here and hypothetically say, well, can't they just split it? Isn't that just a wonderful exercise of craziness to suggest, well, let's just put an arbitrary ownership line here, convey this part to the HOA, convey this part to the HOA, and because some surveyor just drew a line that my clients somehow are satisfied or should be because they're being protected by an arbitrary line because it's now suddenly 2 lots. The point of the matter is these are not conventional perimeter lots around here of like kind, like Brindley Manor. And that is the prime example of what should be perimeter lots. So we also have pointed out that the staff made an error in the primary street designation, and Jeffrey Brown walked through that in his affidavit, and the city didn't even touch on that. They didn't do any analysis for purposes of why he's wrong. They just said in testimony, we don't agree. So we believe they got the primary street designation wrong. But at the end of the day, the primary issue is, does this qualify as a compact development? Now, before you get there, of course, you have to make a determination of the procedural matter of standing, because you've deferred that. Again, common sense is a property owner is not required to have a jury trial on are they actually damaged or not. That's not the standard of standing in North Carolina. What the standard is, the property owner has to allege something that would reflect how that property owner would be damaged in a unique way. And then show up and present evidence to back that up. The city's point is, oh, well, you can just disagree with Mr. Kirkland, Nick Kirkland, who's our appraiser. And I think I heard one of the board members say, well, I don't necessarily agree with what he had to say. And folks, if a property owner who's adjoining a development says the city got it wrong and I need to appeal that, and because what it means is 17 townhouses next to me when there's one house, and I bring in an appraiser to you that says this is going to affect them from a property value standpoint, what more would you ever require? How could you require anything more? What else could we do to prove standing? And if you say, well, I just don't believe him, then really, quite frankly, I don't know if anybody's going to have standing, unless maybe this was a prison or something, a landfill or something like that. But townhouse developments or maybe even commercial, you know, if an appraiser says I've got a problem with it, I believe that it's going to affect this folks' property. If you just simply say, I don't believe, we would never get to the merits of these questions. And your task is to get to the merits and make a decision. Because again, what you decide has a consequence for a lot of different properties in this city, because it applies to a lot of different districts. A lot of well-established historic districts are zoned R2, R4, or R6 in your city. That's your core. And so we're talking about an issue about whether or not a developer can jam in a bunch of density and call it a day by putting the road 5 feet from the property line and no buffer. Hopefully the answer is no, the developer can't. Keegan McDonald got it right. He actually got it right. And at some point in time, somehow that changed. And really, when you ask them, well, what was the deciding factor? It's just, well, it's because that's how I read the ordinance. But he had gotten it right with the first answer given to the developer. So, folks, I appreciate, again, your patience. We would ask that you find that my folks, the Solics and the Bennetts, have standing, and that you agree with us at the merits that this doesn't qualify as a compact subdivision and therefore should not have been approved. Thank you.
Thank you. Ms. Tatum, you're up.
Greg, can you take this, please? And I don't know who all this is, but get to my first. Get this up. Bear with me one second. Just get the, yeah, just show me how to do it. It's off of, it's not up anymore.
What's not up?
The ones where you put it on the side. Okay, just go to 2.3.1. Yeah, that's right. Just bring it down. Right there. That's good. Thank you. Sorry about that. Thank you, Chairman Swink and members of the board. Again, I reiterate thank you for your patience and attention. It's been time-consuming, but it is important for all the parties involved. It is the city's position that the competent material and substantial evidence presented today has shown several things. One of those things is that the Raleigh City Council passed Missing Middle 1.0 with an intent to allow this very type of development. Now, you may not like that type of development. Some people do and some people don't. But the fact of the matter is Missing Middle 1.0 allowed townhouses under the compact development option in R4, 100% of the units at the density set forth in the townhouse option under the conservation development section, which comes out to about 17 units. Now, the second thing is that we believe the evidence shows that the terms of Missing Middle 1.0 and the other terms of the UDO were met and were correctly applied by the planning staff. And not this exact layout and this exact type of townhouse development, because that's fairly new, but the provisions of the UDO themselves, which I'll get to in a second, were consistently applied. Now, they may come to different types of shapes and numbers of lots and whatnot, but the fact of the matter is that the provisions are clear. Okay, I do want to talk about what decision is before you. I know I was a city attorney for 5 years, and we had like one appeal or two, and now there's a lot that have come before the board. This one is a little bit unique because it is an appeal of an administrative decision. And those are the day-by-day approvals that, as we've been through this, you understand that staff does all the time, site plans and subdivisions. Your charge in this situation is different than a special use permit or a variance, where you're the decision maker in the first instance. And that's a quasi-judicial decision, where you weigh the evidence and there's discretion, and you can kind of decide what, maybe intent in some situations. Now, that's not the case here. Now, under state law, the legislature has given the city council two options about how to regulate subdivisions. They can do it administratively, or they can make it a quasi-judicial decision. There are plenty of cities and counties that say, we're going to send the subdivision to the Board of Adjustment or the city council, and we'll have discretionary standards. That's not the case in the city of Raleigh. Here it is an objective, ministerial, non-discretionary, check the box. And so that's what the staff is required to do. And when the appeal comes to you, you stand in the shoes of the staff. And so under the law, you have the same powers and are evaluating the plat with the same standards as the staff. So in that way, despite Mr. Justice has asked you, it doesn't say it in black letters, but you really need a buffer. They meant to have a buffer. It's great to have a buffer. The fact of the matter, it's not required. And in this review, you don't have the ability to add a word or add a requirement that's not there. Now, I want to go through the rules of ordinance construction. Mr. Justice has told you that we have given you the wrong analysis, and that's not true. We've given you a memorandum of law and a supplemental memorandum of law, and the main case cited in both of those is one called Visible Properties, in which Mr. Justice represented the developer and made the same arguments that I'm getting ready to make before you right now. And when you are evaluating an ordinance and the terms in the ordinance, the cardinal rule of construction is that you want to ascertain and effectuate the intent of the legislative body. And that's the city council here. And again, like it or don't like it, the city council took some very big steps in 2021 and 2022 to change the UDO to allow a lot more housing types at a lot higher density and a lot more zoning districts. And so what you want to do here is, what did the city council intend? Now, if the language of the ordinance is clear, it's called the plain meaning rule, and you've got to apply it just as it's written. If it's not clear, there's a special rule that applies, and if it's ambiguous, which means it's subject to more than one interpretation, then you must always construe it in favor of use, which means you've got to always construe it in favor of development. Now, we gave you a supplemental memo, which I thought was important because it's lots, and lot came up a lot. But another black letter law, which is in numerous appellate zoning cases, is that when interpreting the meaning of zoning provisions, and I quote, "The rules applicable to the construction of statutes are equally applicable to the construction of municipal ordinances." And that's from the case Visible Properties I was just citing. So when you're a court, or when you're a board of adjustment, or when you're a zoning administrator, and you want to figure out what a term means, because you don't have discretion, so if it's plain, you just read it. If it's ambiguous, then you pull out the rules of construction. And the first one is the rules of statutory construction apply to ordinances. If it's ambiguous, then you rule in favor of development. So those are the canons of construction that you're required to follow. Now, here, we believe that the terms of this particular ordinance are pretty clear, which is up on the screen, which I keep messing the PowerPoint up. Justin, can you put on that next one, next slide? Here we go. So this is the most hotly debated provision, if you will, that we've been talking about. And so what we've got to do there is apply the rules of construction. And so you've heard Justin testify that this has been there for a while, and that we're going to look at the site boundary, and you'd have three choices: type B1, B2, and in that case, you'd look to section 7.2.4A, or, which is a choice, and that's a well-known rule of construction too, and versus or perimeter lots must meet the dimensional standards of Article 2.2 conventional development option. So that's the rule in black and white. Now, if you have any debate about it, I don't know how that could be any clearer. Now, what we're going to do next, and we've been through this, but I want to go through it one more time, is you go to the open lot standards, this next one, of the conventional development option for that zoning district. Now, the dimensional requirements are in A. Lot dimensions, those are dimensional requirements. You go under R4, there are two requirements that apply because there's no building. 10,000 square feet, 65 feet. This meets this by far, both of them by far. There is no question that it's met. Mr. Justice would have you say, well, everyone that you've ever approved before, which we don't have everyone, we just have several ones that we have brought as examples and ones that he's brought an example, and every one of them are 10,000 square feet and 65 feet wide. Now, some of them do have transitional protective yards or plantings on there, but that is because they have chosen to do that, not because the UDO requires it. And I would respectfully submit that just because other applicants chose to do it, you can't impose it on this applicant when it's not in the UDO. As a matter of fact, I think that if these planners would have told them, you have to do that, they wouldn't have been able to back it up with the UDO. Now, and there are a bunch of cases that talk about ambiguous terms when it can mean two things. And while we think everything is clear, at best, what you could say about these particular provisions is that maybe they could mean what Justin says, and maybe they could mean what Mr. Justice says, but if you have that choice, you are required by the rules of construction to construe them in favor of use, which is in favor of the developer. So that's that one. I want to go now to the definition of open lot, which is a kind of a new, it's the last one. Building type, next one, very last one. The open lot standard. There's been an argument that an open lot can only be used for open space. Again, if you read the plain language there, it says open lots are used to accommodate uses with large outdoor or open areas. Now, I think everybody is in agreement that that is met. And then it says an open lot can. Another rule of construction. Can is like may. It is not like shall. It is something that can happen or may happen. It can have open space, doesn't have to, parks or natural areas. There is nothing in this requirement that changes anything that we've already decided, which is the lot dimension and the lot width. we think that this is really not a complicated issue. It is a very debated issue. It is a hot issue. Mr. Justice told you we've already given him 12,000 documents. You put the term missing middle into our system, and I mean, it blows up. It's something that is, elections have been decided over. But this is not the forum to decide whether missing middle is a good idea or a bad idea. Here, you're sitting in the shoes of the zoning administrator. You're putting the ordinance in front of you and saying, did they check the boxes? And if we have a question, then let's resolve it in favor of development. And we think under that test that the city should prevail. Again, if there needs to be a change to these rules, if there needs to be a buffer, if there needs to be no townhouses, then we would respectfully suggest that that's a question for the city council, an amendment to the ordinance, and not an interpretation that is different than what the ordinance says. So based on that, we would ask that you affirm the decision of the city, and I'm glad to answer any questions. There's the outstanding, I'm not going to go back through that. I have made my points, and you may or may not remember them, but I'll spare you from me repeating them.
Thank you, Ms. Tatum. Mr. Birch.
Oh, well, too late for that. Hold on.
Thank you. Thank you, Mr. Chair, members of the board. Again, thank you for your time and your patience. As you've heard, really this appeal comes down to one question. Does the proposed subdivision plan meet the objective standards of the code? First, you've heard from Mr. Romea. He testified that townhomes are allowed in the R4 district in a compact subdivision under the missing middle 1 text change. So then the question becomes, does the subdivision plan meet the objective standards of townhomes in an R4 compact subdivision? So we just go straight to the standards. First, open space, 20% or 1 acre, whichever is greater. We've checked that box. You've heard testimony to that effect. Width of the open space, minimum 50 feet. We've checked that box. You've heard testimony to that effect. So then we come to the site boundary. There, given the option of a type B1, B2, or perimeter lot meeting the conventional lot standards. As you've heard, we've provided an open lot that meets the conventional lot standards of the R4 district. Here, the plain standards for that open lot. 10,000 square foot minimum lot area. Check. We've met that requirement. The minimum width, 65 feet. Check. We've met that requirement. There are no requirements or standards in the UDO for landscaping that has to be included within an open lot. And there are no provisions of the UDO that prohibit certain improvements within an open lot, including a driveway. You haven't heard any testimony that there are any provision of the UDO that doesn't allow private drive within an open lot. Ms. Tatum adequately covered the whole lot versus lots issue. The law is clear. The city is bound by state law regarding the rules of construction for municipal ordinances. They don't have a choice as to whether to adopt or incorporate some state law. They are bound by that. And that state law is clear that the plural can also mean the singular. And so by providing a single open lot, we meet the requirements of that site boundary standard. You've heard testimony from Justin Romea that the decision in this case and on this subdivision plan is consistent with how the city has applied the UDO in these types of cases dating back to its adoption. Recall that Mr. Romea is one of the drafters of the Missing Middle 1 ordinance. Also recall you heard from Mr. Crane, who was one of the drafters of the UDO. And both of them have been with the city for over a decade, applying and interpreting this UDO. And both of them have given their opinion that this plan complies with the UDO. We've shown you examples of how this has been applied in the past, dating back to even 2016 with the Barwell Park subdivision. That portion of the open lot that doesn't have any buffer, any landscaping, any tree conservation area, any riparian buffer where it is between compact sized lots and the adjoining property. It's just a perimeter lot in that area, which is what's been provided here. You've also heard a number of other pot shots at how the city has applied its UDO. One of those is the primary street issue. Again, you've heard from Mr. Romea that the primary street here, because infill isn't applied, infill standards are not applied at the subdivision stage, that the only role of the primary street determination is for where you measure lot width. And so, again, as you've heard, as you can see for yourself in the plan, we've designated Williamson as a primary street. We meet the 65-foot lot standard there. But even if the other street was designated as primary, we still meet the lot standard there. All of the arguments and attempts to say that the city did not apply a standard correctly, the one source of that information who testified was a person from Asheville who practices in and around Asheville, who had never interacted with the Raleigh UDO before, had never submitted a plan in Raleigh under the UDO before, had never gone through the plan review process in Raleigh before. All of his opinions are from someone looking at this complex document for the first time. On the other side, the folks that are saying that the UDO was correctly applied are the folks that have been with the city for over a decade, who wrote the UDO in large part, who wrote the text changes that are being applied, and who deal with this, interpret, and apply these standards every day. What I take from what I've heard so far is that it really comes down to the appellants not liking the rules that are in place. What I'm hearing is they would like for there to be a requirement for a landscaped buffer. There's not a requirement today in the UDO, and that's what's being applied. They would like for a certain separation. They would like for a certain character, all of these things. The proper place to make the changes to the current rules is not here in the context of an appeal of a plan that the city says meets all of the objective standards of the rules. This isn't the proper place. The proper place is a legislative decision by city council to change the rules. So we are asking you to apply the rules as they are written, consistent with how they've been applied by staff for years, and how they were applied in this instance when they approved the subdivision plan. So Thank you.
Thank you, Mr. Birch. Mr. Justice, you do have an opportunity for a quick final rebuttal.
Thank you.
He has a rebuttal on closing. There's ones we already agreed to.
Mr. Chairman, members of the board, Eric Hodge got it right when he said, the first time I looked at this, I said, what is that thing? What is that thing? You say that when you don't recognize something or something just like, wow, what is this? And, you know, you keep hearing from them about this long, consistent interpretation that really doesn't exist. It just creeps out from a zoning committee meeting, apparently, for the first time in the summer of this year. So he was right when he said, what is this thing? Logic and common sense is that when you have a title of a section that says transitional protective yard, that's the title of the section. And it goes through and it says, here's 3 ways to achieve whatever that section is meant to achieve. B1 or B2, or so A, B, or C. You would think logically that C has to serve the same purpose as A and B. I think I told you at the very beginning, a long time ago, I said if I gave my child a choice between, because I wanted him to learn some learning, to be educated. That was the purpose of my effort to parent him, and I gave him a choice between picking up Moby Dick or Treasure Island, or eat a bunch of candy and watch SpongeBob. Pretty sure all 9.9 times he's going to go with the latter. So when Eric Hodge says, what is this thing? This is not the vegetative buffer, nor is it conventional perimeter lots. And we know that from the examples that have occurred over time, right, from since 2015, when you deal with compact conservation. Remember all the comments from staffers about how very much concerned they are about the perimeter lots or the transition buffer. There's a lot of comments in all those projects. Did you ever see one time one staffer say, forget all that, just give me one common open space lot, regardless of the dimensions? Give me that. The answer is no. We gave you at least 7 examples of compact conservation developments that have been approved in this city, and the staff was very focused on protecting the adjoining properties through either perimeter lots, like Brindley here, or through either riparian or vegetative buffers. So again, we're asking you to apply the plain language of the ordinance when it refers to perimeter lots, and what was shown is not it. I was involved in the visible outdoor case. I do represent a lot of developers. I represent a lot of sign companies. Oftentimes I have local governments say no when they shouldn't say no, and I have to go to the court. That was my case. I understand it very well, visible outdoor. One thing that you're being told incorrectly is this idea that when the court says you construe a statute in the same way that you would construe an ordinance, what the court is saying is you apply judicial standards of interpretation similarly to a statute and ordinance. It's what's called the common law. The common law, how judges read a statute is the way they're going to read an ordinance. What's separate from that is if the governing body of the state says, I'm going to create legislation that says, here's rules of construction, and I'm going to say when there's a singular, I mean plural, or plural, I mean singular, the legislature can do that. City of Raleigh can do that. City of Raleigh didn't do that. The City of Raleigh didn't incorporate rules of construction that was set by legislation. So they are incorrectly telling you what rules of construction are. You are to apply Article 12.1. That's what you're supposed to apply because that's in the code. And when you walk through 12.1, there is no way that what is this, as Eric said, that these are perimeter lots around the perimeter. And I love it that they say, well, it could be ambiguous, because I'll remember that next time I have to deal with, from the developer side, about the City of Raleigh code being ambiguous. I don't think it's ambiguous. They say they don't think it's ambiguous. I don't think the term perimeter lots is ambiguous. And when they talk about, I think Robin indicated my argument about open lot, I wasn't saying that it had to be open space, an open lot. So if you thought that one open lot worked, which I'm saying that doesn't work without a vegetative buffer, these needs to be conventional lots. But even for open lot, the definition of open lot is large outdoor open areas. That's not what that is in pink and in black. That's not an open lot. That's just a gerrymandering to try to achieve a purpose so they don't have to give up any density. I keep saying that I believe Keegan got it right early on with the first initial determination, because what he applied what all those examples we gave you applied, which is if you're going to do a perimeter lot, a conventional one, that means that if you're going to do compact single-family development in the middle, then you need to do conventional single-family on the edges. And when we get to townhouses after Middle Housing 1, guess what? That option wasn't there, because your leaders had not decided in R4 that a conventional townhouse was allowed. So he said then, I'm sorry, all you got are vegetative buffers. So he was applying logic, common sense, in the way they had been doing it before. And so I don't believe he got it right. I believe he did get it. I don't believe he got it wrong. I believe he got it right. So I love the argument that, Jeffrey Brown, really, you can't listen to him because he's from Asheville. I want you to apply the meaning of words the way you understand the meaning of words. He was simply offering up his opinion, just like Justin's offering up his opinion, and Jermont, etc. The good thing about this is a legal question. Regardless of what the outcome is, more than likely we're going to go to court, and more than likely that court's going to apply what's called de novo, meaning they're going to be able to look at it fresh. And from my personal experience, when I come before these boards, oftentimes when they tell you, listen to Justin because he's been around for 10 years, or listen to Jermont because he's been around for 20 years, that's the hill that we always have to climb whenever we say the city got it wrong, respectfully. Because they're telling you, listen to the people that apparently train you, provide you refreshments, and provide potentially interpretation issues all the time. Because you're the Board of Adjustment of the City of Raleigh. And I'm asking you to divorce yourself from, well, Justin somehow has some expertise. Well, they even admitted this issue didn't come up before, this specific issue. So I wouldn't give any weight to exactly, it's Justin, it's Jermont, it's all these people are city employees. Ignore what I have to say or what Jeffrey has to say. Just apply your own common sense and logic and ask yourself, is this what we expect from the plain language when we know the city leaders did not change transition protected yard requirements in R4? When they did not change it, despite the rush for middle housing. When they did change it for R6, they didn't change it for R4. And this is the last chance the city will have to say, we believe conventional perimeter lots is something other than what we're seeing on this piece of paper. This is your opportunity. It will more than likely go to court, but that's okay. We've been there before. But I appreciate all of your patience and time, and respectfully, we believe, like the city, this is a pretty plain language type of case, and we believe the city got it wrong. Thank you.
Thank you again, Mr. Justice, and thank you all for your evidentiary presentations, your closing arguments. It's been a lot for us to consider. Before I officially close this, would the board members like to ask any questions of anyone they've heard from over the course of this conversation we've had over several days? Okay, in that case, let's close the evidentiary portion of the hearing. We've got two decisions to make on both the question of standing, and then on the question of merits. I have been given a suggestion by our counsel that we can ask each attorney to come back with us with their, what's the term for that I'm looking for? A findings of fact, motion for findings of fact?
Yeah, well, you could, so there are a couple of different things you could do now. You could make a decision now.
Yeah.
It is 5 o'clock on Friday or on Wednesday, and you've been here all day, and you've got another day to come back on Monday. You can make a decision now. If you make a decision, my recommendation would be that you ultimately direct the winning party to draft whatever order or findings of facts and conclusions of law related to that. If you decide to postpone your decision, come back Monday or come back some other time, one thing that I've seen done in the past that I found worked very well for the parties as well as for the board was to have the parties draft their own proposed competing orders and findings of fact so that you have something in front of you to read through ahead of time and at the meeting and determine do you like one or the other better? Do you consider it the right answer? Or do you want to use one or the other as a starting place to make changes to develop your own findings of fact? I've found that to be very useful. It really depends on whether or not you want to try and make a decision right now or whether or not you want to come back and give the parties an opportunity to. If you're going to come back, I think the parties, they might not appreciate having to draft the document, but ultimately they might appreciate the fact that they have that opportunity to put in front of you something on paper that you can read and follow rather than trying to remember the last 4 or 5 or however many days that we've been here.
Okay, thank you. That's very helpful. I would love to be able to make a decision, but we have had a lot of information over a fairly lengthy period of time, and I want to ask the board's opinion, starting with the question of standing. Do you recall enough to be able to debate that now and reach a decision, and then move on to the question of merit? Or, having heard Mr. Gallup's suggestion, would you prefer to come back to this with sort of being fresher on Monday with the benefit of them having drafted language which would solidify the issues for us? I'd love to wrap it up, but I'm open to your thoughts. Mr. Rainey, you always have good thoughts on this.
Someone else is already ready.
Okay.
You go ahead.
So start.
I would have liked to have heard more in the, final arguments about each party's position on standing, and because that's really the initial question. So I wasn't thinking about what was suggested about having a drafted motion order, but I would love that. I mean, I think that's a great idea, and I hate to say let's all come back Monday at 9 o'clock, but we could have that before Friday we could look at it over the weekend, and then we can come here Monday having both arguments in front of us and reach the final decision.
Other thoughts? Does anybody feel strongly enough about what they know now to move on the question of merit? We have to make a decision at some point, so being reticent to be first, I understand. And if you want to think about it, we have set aside time Monday after our regular meeting, so it won't be first thing Monday morning, but shortly thereafter, to do this. I would love, and I think for everyone's interest, I think everyone would like to move this thing along with respect to all the people involved. It's a lot of time and effort for not just us, but everyone here. So anyone? Okay, in that case, in the absence of anyone else, I will ask, because we have had it suggested, and it may be, I think, ultimately desirable by the attorneys, that you may not like the task, but if you would, go ahead and draft a motion incorporating findings of fact in particular and consistent with the evidentiary presentation, as though you were the prevailing party on both issues, standing and merit. Bring those to us on Monday. When we open the hearing, we will ask your material to be provided to us. Now, your request was to get it earlier.
Yeah, that would be nice. Get it Friday.
Now, I have to ask whether that's possible. Could we get something to us, could you get something to us by email before Monday? And be, honestly.
To be honest, Mr. Chairman, it's something that can be emailed over the weekend, but I don't think it's going to be possible for Friday.
Over the weekend, possibly?
Oh, yeah. Oh, certainly over the weekend.
Over the weekend? Yes, thank you. If we can do that, if we can get something at least by Sunday midday that we could then have some time to look at, so that we come in Monday morning, we've all had a chance to read it, and maybe that will inform our debate and discussion. So let us...
Mr. Chair,
yes, sir.
If they'll email it to me, I'll be glad to distribute it to the board members.
Excellent. Excellent. Thank you. So, yes, if you will send those to Mr. Gallup, and then he will redistribute. Thank you. So with that, and I appreciate both your willingness to do that, let us act on that you will provide that information to us as though your arguments prevailed, and then we will act on both of those decisions on Monday.
And then all you would need to do is recess until Monday. I don't know if you want to set a time certain, or if, because it's your regular meeting, just as you've said before, just discuss, afterwards, but have some expectation on when everybody needs to be here. Because Mr. Justice and I would, if there was any chance that it would happen at 9:45 because you went too fast at 9, then we would need to be here the night before. But if it's guaranteed to not happen till 11, then I think I would drive in Monday, and I suspect he probably would as well.
Yeah, I think for this instance, I did communicate early on that I actually have a conflict Sunday evening, and there's no way for me to drive in, that I needed it to start by around 11 to give me a chance to drive here.
We did, in fact, agree on 11. Monday, we actually only have, I think, 2 items starting at 9. So what may happen is we may finish our business and then everybody work here for an hour until and when you're here, we'll hopefully be ready to go.
In that case,
Mr. Swink, hold on one second. There may not be any case.
We just don't know yet about the new business case, and then the only other one is the Fathers Forever.
Oh, well, okay.
Yeah.
Okay, well, I'll tell you about that. I just want to make sure not everybody comes in here and doesn't sit around for a couple hours. One of the items is Fathers Forever, and we've all agreed to continue that.
Right.
Okay, so that won't be heard. And so that leaves one other that you say is kind of up in the air.
It's a variance.
So do we need to start at when?
Unfortunately, I don't think we know yet. I think it's likely that we wouldn't need to start
At 9?
No, I don't.
Oh, yeah, I don't think, but that's why I was thinking,
But
what,
we just won't know until we hear back
10?
from the applicant.
9:30?
I guess as early as
9:30?
they're able to.
Yeah, there's going to be one variance case, I guess. I was just trying to help y'all.
There's a variance, and it's been advertised
Yep.
at 9, so I
Oh, okay.
isn't there an
Okay.
obligation for us
All
to
right.
then start at 9?
Yep.
Okay, so I just realized it just means we'll do our business, and then we're going to have a gap.
And I think the best thing to do would be to recess this till 11 on Monday, and then retake it up at 11 on Monday.
Yeah, I think so. Okay, well, again, with respect to everyone's time and interest in this, trying to be efficient with our time as volunteers, we will recess this case until Monday at 11. The rest of you, I'll see Monday at 9. And thank you, all thank you for all your patience today, and thank you for the air conditioning coming on here at the end of the day. Wish it had been sooner. We stand adjourned. Thank you, Ms. Clark, for your time today.